matter, old matter, fresh matter.
2021 matters.
You want a final hearing.
Yes.
Final hearing, you will have to move an
We
application.
already moved a stay vacate application. We already moved a stay vacate application.
Stay vacate. What is the IA number? Tell us. That's all.
IA number 1 of 2021, 2 of 2021.
Monday, Tuesday. One applications comes up on Monday, another one on Tuesday. You choose which one.
Both connected matters. That's why I'm mentioning it.
4th September. Monday. Only on vacation of stay, not final hearing. On vacation of
Interlock.
IA.
Caption interlock.
Yes.
Matter.
A similar matter.
Similar yesterday format. Connected matter. Unfortunately, it was not listed as tagged.
Learned
notice for
Mr. A. Venkatesh, Learned Senior Counsel. This is all.
Lords, I take notice for respondent 2 and 3.
List for notice on behalf of
Respondent 2 and 3. We are opposing the leave
Mr.
application.
Harendra Prasad and Senior Counsel, whatever.
I am
4,
appearing
5,
for
7, 8.
A. Raghuvi Reddy is appearing for 2 and 3.
Huh?
There is a leave application. We are opposing that. We'll file counter for.
Leave application.
Yes.
They are not parties.
They are not part.
All right.
Third party will be filed implying application that was dismissed.
Send issue notice of IA 1 of 23, 2 of 23 and 4 of 23, right? Then these people accept notice whosoever. Mr. 4 to 7 is accepted by Mr. Harendra Prasad, Learned Special Government Pleader attached to Office of Advocate General for State of Telangana. You are accepting for Mr.
2 and 3.
2 and 3. Learned Senior Counsel for the applicant. Yes, then right. This. In this, Mr. There is a condonation delay, so we will have to
11,
condone
yes.
the delay.
Yes.
First. What do you condone? Delay?
11 days of delay.
Yes.
So then you say, no, all parties are not represented, but
But the rest are all the government learned representative to take it.
everybody is represented
Yes, my lord.
at this stage.
Yes, ma'am.
Yes.
Now then, heard on IA 2 of 23 for the reasons assigned in the application, duly supported by an affidavit, we find that sufficient cause for condonation delay of 11 days in filing the appeal is made out. Accordingly, delay in filing the appeal is condoned. Learned counsel for respondents pray for and are granted how much time?
2 weeks.
2 weeks time to enable them to file counter to IA 1 of 23. Learned senior counsel submits, right? 1, 2. Submits. It is also pointed out that the writ appeal involving similar issue has been entertained and an interim order has been granted in support of a process submission. Reference has been made to order dated 31/8/2023 passed in WA 868/2023. Paragraph in view of a process submission and with a view to maintain parity. It is directed that no stay. It has already been stayed.
Yes.
All right.
Already.
Delete. The interim order has been granted, right? Then delete in view of delete list for analogous hearing along with WA number 868/2020.
Publish.
Oh, rare occasion when you are this side. Now what can be done? Everything is over. 1st of August till 30th.
I do understand, but the weekend order, my lord, it's not applicable to the respondent. My lord, on account of this, my lord, the matter was
Damage has been done.
more than 30 lakhs, my lord, the damage has been done. My lord, now matter has been moved to lunch motion. My lord, we sought the instructions, my lord, at least one accommodation. My lord, otherwise, my lord, venture, my lord, to file the appeal.
Hey, what?
When last may, my lord, kindly to let the matter be adjudicated. My lord, I'll file a vacate petition for the single judge, my lord.
Ah,
My lord, so that, my lord,
you will file a vacate petition. I grant you the liberty. Ah, yes.
Milord, new Milord may make contact. My friend is not correct, Milord.
No, he can.
On that day,
Mister, 1 minute. You can't prevent him from filing a vacate petition. Nothing.
my friend says,
day time was not given. It is not given on that day. The council-
We are not deciding what is correct, what is not. We are only granting him liberty to file an application seeking this thing, vacate petition.
That
You are praying, right?
Mirror, I'll file vacant petition that way.
That's what.
Mirror, without going.
That's the first thing we said, but still he wants to vacate, file vacate petition. You say, argue before learned single judge, it's all over.
certainly.
Let the matter.
Nothing can be done. Application,
Let the matter be adjudicated on merits, that's only
We
merit.
can't say that, like, that single judge has to decide.
Because mirror, more than 30 lakhs are being incurred.
No, that is, Mr. Then file an application.
Mirror, file.
Appropriate application now that stating whatever you are arguing that in pursuance of interim order, he has run away with 30 lakhs at flight risk, therefore be detained at all ports wherever he tried to
That's on
board the flight or whatever.
Yes.
Like, and therefore this amount should be recovered or he should be directed to furnish security, whatever, that is the application.
Well,
Don't, instead of vacation, file an appropriate application.
mirror, I'll file.
This intra-court appeal has been filed against an interim order dated 18th day of August 2023 passed by learned single judge, by which the order dated 16/8/2023 passed by the South Central Railway attaching the racks
Mirror,
parcel van,
van.
attaching the parcel van has been for a period from 16/8/2023 to 30th August 2023 has been stayed. Paragraph, learned counsel for the appellant fairly submits that the order, interim order has lost its efficacy as the period has learned counsel for the appellant fairly submits that that since the period has already expired on 30th August 2023, he be granted the liberty to file an appropriate application before the learned single judge. In view of aforesaid submission, the writ appeal is disposed of with the liberty to the appellant to file an appropriate application before the learned single judge. Needless to state that if such an application is filed, the same shall be decided expeditiously by the learned single judge. Accordingly, the appeal is disposed of.
Well, this to be taken up along with 19 million.
NCC quota,
Yes, Maharaj.
there is already an order.
Item 19 is there, Madam. You lost
58
it in
and
the plan.
58 and 59.
Yes, madam. 1% reservation quota, that is the scrapped and amended.
Heard on the question of admission. In this petition, petitioner has assailed the validity of amendment made by insertion of clause small Roman 3 within bracket A of Rule 4 of Telangana Medical and Dental Colleges admission within bracket admission in MBBS and BDS courses bracket close rules 2017, by which provision prescribing for hierarchical reservation of seats for admission to MBBS course to the extent of 1% has been deleted. Paragraph, a writ petition involving similar issue has been entertained and an interim order has been granted. Therefore, this petition is also admitted and it is directed that any admission made against the seat under NCC A and B quota in MBBS and BDS course shall be subject to outcome of the writ petition. List for analogous hearing along with WP number 21192/2023.
But for the respondent number 5 and 6, my colleague name is in there.
5 and 6. Mr. Praveen Kumar accepts notice. It has not been examined by anyone. 16(2)(c), you are sure not examined by anyone?
No, my lord. Other high courts have held, my lord, that
The seller must be proceeded with instead of proceeding as
No,
a
no,
buyer.
this validity of this
No,
provision.
no, it's not it. They are all pending
Learned Senior
before.
Counsel submits that the validity of section 16(2)(c) of CGST Act
I do not.
sitting there. Learned Senior Counsel for the petitioner submits that the validity of section 16(2)(c) of CGST Act has not been examined by any court of law. In view of aforesaid submission, petition is admitted for hearing, issue notice.
Mr. Dwarak,
But there is a stay will not requesting my lord stay of recovery.
no, but the matter had fallen for consideration in Bharati Telemedia.
No, that is my lord in respect of whether it should be reflected in GSTR 2A and what is the sanctity of that.
And
There are other high courts my lord have held that seller must be proceeded with and the buyer should not be penalized. There are a similar.
Learned Counsel for Senior Counsel for the petitioner shall also place on record copy of order in copy of order. Along with WP number 705 of
2023.
23, you accept notice?
I'll accept notice, my lord, for first response.
Mr. So and so accepts notice and praise fund is granted 2 weeks time to 3 weeks time to enable him to file a counter to IA number so and so, 1 of 23.
Obliged.
Give a date.
Once let them file counter, you can always mention, Mr. And there is it's not that after 3 weeks meeting, it will never come up. Because,
I will admit it. There is
no, up-to-dating system. Admitted, this thing, we can't, on the next date of hearing, decide and declare provision ultra
I'm
vires.
not saying
No.
it's to file their counter.
They will file within 3 weeks. Their prayer for yours after interim relief. We don't want to grant an ex parte order. We will, nothing happens. Your amount is safe. The only thing is it will be refunded along with interest if you succeed. But
But I-
still we want to give him a count, this time to file counter. Yes.
Deeply obliged, madam.
In this matter, I am depending on behalf of Ratnaprabha Maharaj.
3 to H.
She was 72 million. He was 72 million.
Even on 6th, my lord.
Heard on the
Last
question
question,
of
it will be
admission,
posted and-
petition is admitted for hearing. Learned counsel for the petitioner submits that the same order, Mr. After passing this order,
My lord.
we know that. Do you think that we don't know the order which we are passing? Same order and then list on 6th of September 23 along with WP number 24052/23.
Relative management quota.
Management.
BNC category registration.
You will consider
Yes, ma'am. Same order.
Page 25, lordship's order.
page 25.
Similar order.
Page not 25, it's page 27. huh? 27 is the order, right? Same disposed of, certified copy today. Oh, before you could say we have told him CC today.
Obliged.
Deeply obliged.
I beg to represent
Oh,
Sagar.
yeah.
My lords, the petitioner is before your lordships for the second consecutive.
Similar
time.
order 36.
No, no, ma'am.
No,
Your lordships passed an order which your lordships would find at page 36 to 38. The applications directing me to go and make a representation to them and they consider. I am now for your lordships on a slightly different point. I am saying that when your lordships say consider, they just can't say the High Court said consider, I consider, reject. That makes a mockery of both the judicial order passed by this honorable court and vitiates the test of a decision-making process test
Which-
that your lordship should consider. Page, the impugned order your lordship would find at page 15, 1-5.
1 5.
Your Lordships kindly go to that. Your request is not considered as it is contrary to the orders issued by the government of Telangana in rule for admission to GOMS dated so and so, and they extract the rule. The rule which says, notify
Find
the
out.
university with the following words shall be no.
Seek his
restriction.
All right.
I am saying.
Alright, senior, let him take instructions and we post it on Monday.
Obliged.
Learned senior counsel for the petitioner submits that the representation submitted by the petitioner has been rejected by the university on 23/8/2023 by a non-speaking order. The order passed. Right, what have you done? Nobody can, it's not that when we say consider means you have to apply your mind, assign reason one way or the other. We are consider means not consider positively. You can reject also, but it should show application of mind. You don't say anything.
Speaking order.
So you produce speaking order on the next date of hearing Monday instead of contesting, focusing on this, that how to save this order.
In which case, my lords, they'll have to answer the Mohinder Singh guilt test.
No, separate order.
Separate.
But no, if you want, then that technicality, then we quash it right away and ask them to take a fresh decision by Monday.
Let them come on Monday. Let them come on Monday.
But that's better.
I'm obliged.
Later on. Medical entrance, not management.
No, Mr.
Covered by all.
Last,
Your lordship started paying.
nothing covered. First answer. Last date for submitting online, the online applications were required to be submitted for from 4/8/2023 till 12/8/2023. Why you did not submit up to 12/8/2023 and why have you filed the petition on 31/8? What happened for period of 18 days in between and what is the explanation? Show us a single reason why from 4/8/23 when everybody else could do it, why you didn't do it? Prima facie,
In fact,
Mr. We do not find any justification in your petition. Please point out from para, which para you have explained that I was in South Pole, therefore no internet access and did not do it. No explanation.
But he said he'll be not there.
Ask him.
Mr. Bhaskar.
Yes.
Your last date as per your own admission was 12.
For A category, Miller. Now B category is not yet notified. Because B category is not yet notified.
What is B category?
Management.
Mr.
B category, Miller.
Not notified.
No, already, Miller, 12/8/2023 was the last date for online registration.
Date of counseling was not notified.
Date of counseling was not notified.
But you are seeking permission to apply online, not consider.
I applied already online.
1 second, boss.
Which order? He is unable to put the case. You tell him what is his case. No, brother wants to tell you what is your case, which you are not pleading. He will tell you.
In short, your cases I have applied online. I made an application. I only selected A category.
A category.
Did not by oversight. I did not select B and C
B
category.
and C category.
That is your case in nutshell.
Yes.
That you have not told us. Don't be dependent on the bench for finding out a case for yourself and then make out a case for your petitioner and then grant relief. Otherwise, we will, this thing have the first charge on instructions which you have received. Correct?
However, in that it should not include each other.
You should say no similar order.
Page 19, 20, page 19.
What will happen? These people. You are not saying that similar case we have already granted the relief.
So referring to page number 19, Millard.
Not saying, mister. First sentence you should have said is that similar orders are page 19.
In fact,
You are not
Millard,
saying,
I thought that maybe I'll
Yes,
place
Mr.
the facts and submit.
Your lordship will directly.
there is no time. No time. Till 1:30.
And
You have to be quick with this bench. You should have first simply said page 19 similar order.
I understand.
This order page 19 certified copy today.
Publish.
Mr. 33B, this order which we have passed yesterday.
In fact, my lord, the petitioner claiming he has not registered for B category registration, my lord.
No, this yesterday, Mr. After hearing Mr. Rao, we have passed an order. He will make an application. Tehsildar will be satisfied within 5 days and then treat the petitioner as local candidate.
Yes, my lord, in fact, my lord, your lordship can affidavit of the petitioner, my
No,
lord.
no, Mr. Once the issue has been concluded, you cannot argue in every case.
No, this is the case where, my lord, the petitioner is asking for management quota, my lord, and he could not register for the management quota B category in time, my lord. But so,
He has challenged validity of Rule 33B. Rule 33B he has challenged.
I filed my reference certificate also. What? No, this is the case.
No,
where-
no. What is the relief claimed in the petition? Either we are wrong or we have to correct or you find out.
Petitioner as a
No,
local.
the petitioner claiming admission, my lord.
Challenge the.
Under local
read
category.
Page 9, page 9. Yes, challenge the validity of the rule. We have rightly or wrongly, we have read the rule down. Therefore, Mr. How you cannot argue in every case
No, it's
that he is not a local candidate, not.
My submission is.
This, Mr. After hearing Mr. Rao, we have passed an order this.
It's no,
The Tehsildar will conduct an inquiry, issue a certificate. All these facts we can't decide.
your
You
lordship.
are trying to say that he is not a local candidate.
Not like that, my lord. He has not registered, my lord. First of all, to be eligible for admission, my lord, he has to register himself for online registration, my lord.
Online not submitted.
Not submitted, that is my.
Mr. Then gone. Yes. Why did you not submit the online application, Mr. Council? 12th of August.
46, I have submitted the web portal, page number 46.
See, Mr. Sorry, on facts, there should be no dispute, right? This you have to be.
Even I have written the reading of mail.
Show him why is he saying not applied? Page 46.
Yes, my lord.
Like.
Whether he makes it or not, it's a separate issue.
So, a category is applied and he is entitled for consideration. This order will pass, that is the
Same order, yes, please.
Your lordship.
same order.
Same order.
Same order, certified copy today. Now you go home, Mr. Whatever, I mean, go home means go there and start typing. Because all today matters you are taking.
Yesterday I told you, 2 orders, somebody keep changing, so.
But all today matters you have got. Yes.
I can tell
Yes,
Yeah.
actually.
What is the relief claimed in the petition? Relief claimed in the petition.
So,
Will you read it for our benefit?
This is the,
Relief claimed in the petition.
Lord, this is the appeal, Lord. I have.
Read
Just-
page 18.
Yes, sir. Page 8, reliefs. View of the above submissions, it is therefore prayed that this honorable court may be pleased to issue with orders, direction, more particularly one in nature of the mandamus, declaring the Act number 12 of 2018 dated 12 April 2018. Assigned land, assigned lands prohibition of transfers amendment act 2018 as illegal, arbitrary, biased, unconstitutional, and against the principles of natural justice, violative of the rights guaranteed under Article 14, 21, and 300A of the Constitution of India, as well by violation of the true spirit of Telangana.
Violation needs to be corrected, right? Spelling you will appreciate. Huh? It's not VAL. All right. Then next read true spirit of
Yes, spirit. The spirit of true spirit of the Telangana assigned land.
Sprite, right? You are having Sprite while typing the petition, so it has come Sprite here.
Sorry, Milad, I just critical mistake.
Then
Assigned
go
lands,
for
Creation of Transfer Act 1977 and consequently set aside the same and pass other orders in the direction as
So you have challenged the validity of Telangana Assigned Land Prohibition of Transfers Amendment Act 2018
yes, ma'am.
on the ground that it is violative of Article 14, 21 and 300A, and according to you violation of natural justice doesn't apply, but this is even assuming that's your ground.
Yes,
Correct?
Yes.
So then how is respondent number 3 is a necessary party?
Milad, the respondent number 3 is as the chief
One
Justice of
minute.
Telangana.
This can't be done. We will dismiss the petition. He, in a personal capacity, he cannot be impleaded, and you have not claimed any relief against 4 to 8 also. So all these persons cannot be impleaded.
Madam, my submission is that Milad.
You want an order to be passed,
No.
or you will delete. See, Mr. Either you delete 3 to 8 or we pass an order.
So can I be submission please, Milad, nice.
And this is a public interest litigation. You don't have any locus. Now you have brought the matter to our notice. We will do it.
Chief Minister of Telangana.
Then you will retire. Nothing.
Kindly post on Monday, Milad. Clarification my case.
Nothing. This is a public interest litigation. It is not a regular litigation and adversarial litigation. You cannot play hide and seek with the court. Understand 3 to 8 are not necessary parties. We are passing an order if you are not agreeing. All right. In this petition, yes, madam, right.
So in P number 82 of 2022, I recorded the so we are valued as a personal purpose at the CM blood.
Your bill is not being registered only because of what you have done.
So kindly Milad, full clarification on Monday, Milad.
No.
So please.
Monday we have other cases. Today is the day meant for your case. Don't develop a habit of posting. If everything is posted on Monday, then what happens? Nothing happens.
No, but
We will not adjourn.
This is the
Nothing.
Milad.
No, having filed the public interest litigation, you must be on your toes. Nothing. And you know this is frivolous. We will impose cost on you personally if you recovered for drafting such a petition and for signing it. Right? This is
Okay, my delete my.
Mr.
Okay, my.
You delete Mr. Prabhakar, tell him he has challenged you have challenged the validity of statutory, Mr. Prabhakar. You have challenged the validity of statutory provision in so many cases, right? See what he has implemented. No. Mr. Prabhakar, see what he has implemented. Whom? 3, 4, 5, 6. 3, 5, 6, 7, and 8. See, Mr. Prabhakar. And see the prayer clause, page 18. No. Relief clause. Please see. Relief clause. So therefore, what should we do? You guide, tell us as an officer of the court what we should do against the learned counsel.
Act is passed by assembly or parliament. If all the MPs who took part will have to be next party. If this is.
No. So supposing Mr. Brother says that if an act is passed by the parliament, then everybody, whole government and all members of the parliamentarian should be implemented because they have passed a law. This is frivolous, Mr. Are you deleting? In view of office objection raised by the, in view of office objection, learned counsel for the petitioner undertakes to delete the name of respondent number 3, 5, 6, 7 and 8. Let this be done during the course of the day. After the, thereafter, only the office is directed to register the petition as public interest litigation. You do it just now. So it will be registered and we can hear you on admission. That's most important, right?
Right.
No, madam, for this, my list has gone past.
My I have for a third respondent.
Give the record to him. Delete. Ask him to delete right. Yes.
I have the appellant.
Yes.
The appellant is being a lady and is having 16 guntas land survey number 86 at Chinchapalli village Mila. The land grabs occupied the some part of land and obtained permission from the Gram Panchayat.
Okay. What is the record? There was an order.
Earlier, the Salmo directed the secretary to file what are the procedures followed by.
What record why court wanted to see the record?
Audit of hearing will have directed me to any functions within online or offline. At that time, the officers given on offline. Because at the time, the systems are not working. The systems are not working. These permissions given on offline. There is no embargo.
Building permissions were made online. Here in this group, we are saying that was not implemented. So it was an offline permission. No, but this was valid from this to this. Correct. This is valid from produce the record to say that it is an offline permission and so that you can say produced. So that it can be seen whether one day before, one day after, also it was manual or not like this.
Permission record. Yes.
Produce the record. Oh. Very colorful record you have got, right? All the red, what?
Long book is without permission.
See, before and only for this purpose.
So they have been granting this thing offline permissions, which is apparent from the record.
But may I explain?
No, but how can you interfere, Mr. Mr. One minute. Listen to us. I mean, we will hear you, of course. No order can be passed without hearing you. But see, once the petitioner has a valid permission, right, up to from 3/11/21 to 3/11/2023, how can anybody interfere with the construction activity without there being any court of law? You seek an injunction against him, restraining him from carrying out construction. But you cannot interfere this thing. That's what the division, this learned single judge has held. So long as the construction is being made in conformity with the building permission, this thing, no interference shall be made. And the municipality has been given the liberty that in case any deviation is found, action will be taken.
Yes.
How can you interfere with the construction raised by a person in accordance with the building permission?
May I submit to
Supposing
you?
if you, 1 minute, supposing if you want to construct your house,
Yes, sir.
what will you do?
Certainly, to get up.
You will obtain building permission.
Yes, sir.
And you will instruct the contractor to carry out the construction in building in accordance with building plan. Right? If you are constructing your house, will you not do this?
But illegally they granted building permission to the petition hearing.
That is illegal building permission, then appeal. And that provision writ is not the.
See, your main case was that it was online and there was no permission that was granted. That is why we have directed to produce the record, because one of the contention was that during that time it was a manual. You had disputed that. That is why we have directed them to produce the record to see
That is produced.
whether it was online or offline. So this shows that all, not only your permission, before you, immediately before your permission and subsequent to your permission also, everything is manual only. It is not that it is yours is either last or the first. It is,
I submit,
there are subsequent to your 310 or 311, there are building permissions of 1511, there are building permissions of 12th January, everything is
Without following due process, they issued a building permission to the writ petition.
That's a separate aspect.
You have to, any person aggrieved by building permission has to challenge it. No.
Act also.
Not, that has not to be challenged in a writ appeal, that has to be challenged before we are sure there has to be a provision under the Municipalities Act. Any person aggrieved by a building permission can challenge the municipality, you do it. Not in a intra-court appeal against an order the permitting him to raise construction. Scope is of this appeal is only confined to examining whether the single judge has rightly issued the direction.
Filed to writ separate petition 13909 of 2023, 1289 of 23, cancel the building permission granted by the secretary without following due process law. Property situated agent.
No, you have filed a petition.
Yes, Milan.
So that you pursue that. There is nothing wrong with this.
Without following due process, they issued.
No, you have challenged it in
Situated.
What?
13909 of
13909
13909
of
2023. And another 12897 of 2023.
12897 of
2023.
correct. You know what to do and you have advised your client rightly. There's nothing.
That is necessary petition.
Nothing.
Adding the.
No. So you want us to pass an order in this writ appeal and render writ petition filed by you infructuous, by saying that division bench has already held in my favor. How can we decide against that issue in this intra-court appeal, which does not arise, which you have already filed a writ petition? You withdraw with the liberty to prosecute. This intra-court appeal has been filed against an order dated 28th of April 2023. Learned Counsel for the 2023 passed by Learned Single Judge in WP number 12656/2023, by which writ petition preferred by the petitioner has been disposed of by restraining the respondents therein not to interfere with the construction activity carried on by the petitioner so long as construction is made in accordance with the building permission issued on 3/11/2021, which is valid up to 3/11/2023. Learned Single Judge has further directed that in case any deviation is found by the official respondents, they shall be at liberty to take appropriate action in accordance with law. Paragraph. Learned Counsel for the appellant submits that the petitioner has obtained building permission without due process of law. However, it is clearly submitted by him that the building permission obtained by the petitioner has been assailed by the appellant herein in two writ petitions, namely WP number 13909/23 and WP number
Lender single to dispose of my writ petition.
Huh?
Directing to lender single judge to dispose of my writ
No.
petition.
You make a request to him. This is, learned single judge is not subordinate to us. This is all, it's only in intra-court, this intra-court is
Basing on this article, they are
to correct the manifest errors.
basing on this article, lender single judge, land is trying to.
File an application. File an application for early hearing before learned single judge. This is beyond the scope of the appeal. 12 also same order. Yes. Yes.
Item 13, expense delays the scheme.
Well, sir.
What the order comes, no separate orders are missing. No petition. Okay.
And leave granted.
Leave granted.
Lots of the permission, madam.
Ah.
This matter I am requesting on Monday.
13.
Item 13. GP is out of station minutes, is not a turn up, requested on Monday.
It's a show cause notice, mister. Who is the for petitioner?
I'm for 11th.
Appellant. Yes. What you are saying that without jurisdiction? That jurisdiction issue can also be raised before the authority. What is this?
The district corporate, the register has got power, but district corporate has no power. Kindly see the rules.
Registrar.
Register corporate society has got power,
And not,
not a district corporate office.
so instead of, by now, you should have, we said, you should have said that it will be issued by competent authority and should have got ahead instead of saying that GP is not there. There is a stay in his favor, he is very comfortable. He will say take 4 years time.
Only we are expanding.
We will take it up in 2030. Do you understand? This court has granted an interim order by, he is happy. You are not serious about things, right? They don't bother, Mr. You be happy. Why to? They are not bothered. He is a department. You are this thing, no government department, Department of Cooperation. Not bothered. Enjoy. What? So what do you do?
My submission, yeah.
You want a decision on vacate petition. You want a decision on vacate petition. All right. We will hear them. It's his application in senior counsel. Fine.
You might see the order. And it on page 27 of my wicket.
We hope that you have gone through order dated 19/7/23 by division bench. 19/7/23. You have gone through.
Page 27.
No. Order passed by division bench of this court. You have gone through, right? 19/7. You have gone through it.
I find on page 26.
We have it. Yes.
Now, the ground on which the interim suspension is granted,
Yes, sir.
DCO responsibility has not been reached.
Who is DCO means District Cooperative Officer.
Well, it is the Geo 10.
In your generation, people did not use abbreviation. The abbreviation is new in thing for younger generation, right? Huh? So you are telling us that you are young. District DCO.
It is taken help of.
And this thing, Mr. This notice has been issued by District Cooperative Officer, and your submission is that the jurisdiction vests with
It's with the registrar.
Registrar Cooperative, sir. Rule section 21AA B.
Yes,
Give at a cooperative society. 21 AAA B 1A B of Cooperative Societies Act.
Page 31.
So we will very well decide the petition itself. What is their vacation and this thing?
Here,
No, but see, it will be heard decided without hearing the GP.
Because there are
on the GO10 only. The GO10 it's clear. No, on the day when it was heard, and the subsequent paragraph was not read out. So that was the mistake of council also. I don't, but yeah, GO itself is clear. As the jurisdiction of the GO. Uncertainties have been.
1 minute. 21AA,
Yes, sir.
Mr. What is 21AAB?
21AA, not 21.
21AA,
21 AAC, any person is in the commencement of the Andhra Pradesh Cooperative Society Amendment 1970, member of committee or more than 2 societies. So that is not the 21 AAC. He is suspended 21 AAB. On inquiry on the case, he found guilty of misuse of property of society any person.
no. So it doesn't say that registrar or which person.
Section 3, Section 3 of the Society Act.
21AA3.
No, Section 3 of the Society Act, Section 3. There shall be upon registrar cooperative society for the state.
This all appointment of registrar and officers under the act. Where is where does section say 21AA that power shall only be exercised by the registrar cooperative society as no one else?
Kindly
Then
see
nothing.
number 2.
That's what we are trying to know.
Person appointed.
Mr. Senior Counsel, please appreciate, we want to know where from you are getting that this power can be exercised only by registrar cooperative society,
No, my lord,
because
under,
it doesn't say so.
under section 010, my lord, issued
Huh?
31 2017. Delegation of
Section
powers.
10,
Delegation of powers.
under section 10,
GO number 10. Issued by the government.
what is GO10? Not under the act.
No, under section 3, my lord, delegation powers given to the some authorities to function as the registrar.
Confer on him. So
Yes.
this is conferment of power.
Yes.
This is an executive, this is an order passed under section 3.2.
This is passed under 3.2, my lord.
3.2. Yes.
Kindly see, my lord, page number. The letter number second, Commissioner for Commerce Registrar. So Telangana, Hyderabad, State, by GO 145 finance, so.
So where is it, Mr.?
This one, this is kindly go to columns, my lord. Authority. The district collector, district cooperative societies has given his powers.
No, you are a what? Primary agricultural
Primary
cooperative society.
Yes, my lord. Primary
Yes, Mr. Primary agriculture
Yes,
cooperative
correct.
society.
Kindly go to page number 2, my lord. GO number 10. Deputy registrar, cooperative societies. For district cooperative societies has given powers, this my lord. For other district level powers on column number 3. For primary agriculture cooperative society, only power of the registrar under section of 11C of the act subject to guidelines issued by the registrar. Only powers are given.
No, where does this GO say that power under section 21AA, B and C or whatever shall be exercised by district registrar alone and nobody else?
They are not given 21A, my lord. Entire powers of the registrar was given under
Get it, brother. I am unable to understand what is the argument.
Okay, Mr. Such power. Extent of this deputy registrar can exercise power to the extent of powers conferred under section 116C of the law. It is conferred on the registrar, even the deputy registrar can exercise in respect of registrar. Now, the 116C.
Where is this?
116C doesn't confer that power under 22. No.
It is a specific conferment.
Power is only by the registrar. Every power can only be exercised by registrar, but by under GO, it has been delegated to deputy registrars.
It is by district cooperative officer. So this is again not district cooperative officer. This is deputy registrar.
Deputy registrar, who is equivalent to deputy cooperative. Is the same track.
So deputy registrar and deputy cooperative officer are same authority, right?
Yes.
So your submission is that the delegation of power of this says that powers of registrar only under 116C have been delegated to deputy registrar.
Yes,
So therefore impliedly the registrar has to exercise power under 28A
yes, madam.
of primary cooperative society, correct?
That's correct.
What you said? So you said not read whole and full of.
That aspect alone. My learned friends.
So they are taking trouble to argue the matter. Finally, we are deciding it, right? You can inform the whatever happens to the government leader that this is what has happened.
116 means only with starting. Only that power has been subdelegated from the registrar to deputy registrars.
Ballot now, coming to the ballot, on page 22,
Yes.
on page 22, same, my lord. Now, my learned friend says the serial number 2, the power is restricted or delegated only in respect of 116C. That is the starting pattern.
That is
None else is there. Now, your lordship may go to the same page, item 3, last bottom. My lord, deputy registrars, special category deputy registrar, joint registrar, working as district cooperative officer. This is the impugn order passed by the DCO.
No.
What is the now? This lordship may say on page.
We are trying to understand, right? Like this thing, the next column is, you are saying that is in respect of urban banks, not.
On page 23, your lordship may go. 23.
So you are referring to this.
Petition which I have filed, my lord, page 23, continuation of GO. Continuation of GO. Continuation of
You want to say that this is incomplete geo handed over to us?
Yes.
Already,
Your lordship, for a moment, see page 23 of my vacate petition.
No, but it is perfectly all right to smile when you file a vacate stay petition.
No, my lord, my submission, my lord, is.
No. While making submission, you can smile. That's what we are saying. Nothing beyond that. We are not saying you can't make submission.
My only submission and confined is whether the DCO has the power to pass the order under.
Saying that he has power, you can smile. That's what we are saying. Right? Which vacate petition, which page, madam?
Vacate petition, IA2.
Not there. When did you file? When did you file vacate petition?
Yes.
See, after wasting spending so much of time, then we learn that vacate petition is not on record. You give your copy. No, but you all accept that document is not available anywhere. Anywhere. In this book also not available.
Yeah, the GO, your lordship.
Hey, Mr. Senior Counsel, this should not be like happen. Is he correct in saying that you have filed incomplete copy or handed over incomplete copy of GO? He's saying incomplete.
he has given the copy,
Ah.
but we will not before the court. I can skip it.
Your lordship, for a moment, see page 23.
No, we are only asking, is he correct that there are some more pages to this GO?
No, Milan, no.
Nothing.
At the end, Milan, that's.
End is there, section officer. How can you say, Mr.? Give vacate petition.
Item 3.
No, it's there at page
Yes.
3. Why are you saying that it's not there in incomplete? Mr. I mean, saying, 1 minute.
I'm sorry.
1 minute. No. See, Mr. 1 minute. Saying that he has not read whole of it and I will read the relevant portion is different than saying that incomplete.
I'm sorry, madam.
No, this is not. It's serious issue against this thing, senior counsel. You take this copy, your copy. We have it. Yes, 6.
Serial number 3, item 3. Deputy Registrar of Property Society.
No, there is not item 3, serial number 6 you are referring to. 6, Mr. Page 3 of internal page 3 of GO.
Your lordship may take
page 22 of my vacant petition.
We don't
Yes,
have your.
serial number 3. Serial number 3. Mr. Gordhanachari, we are telling you repeatedly, we do not have your vacant petition in the GO, which is your lordship on page 23 is the relevant portion. On page 23 of what? Yes, my lord, society. Page 23 of relating to the power of TCO to the rule. Page 23 of what? In vacant petition. That's
When have you filed the vacant petition? Mr. Tell him that his vacant petition is not on.
Different with GO also.
Vacant petition.
When he has filed.
He has filed on, that is on 10/8/2023.
It's not on record, unfortunately.
Huh?
If you are insisted only from reading from para 23, page 23, we don't have it.
Well, because the vacant petition is coming for consideration. IA2 of 2006.
We will take action against the person who has not put it. We will take action against the register of the officer who has not posted.
To add, my lord, that it is,
Who are you? Respondent number? Who is the?
This one number 2.
Learned counsel for mark the presence. Learned counsel for respondent number 2 submits that he has filed a vacate. No, delete. Mark the presence. Learned counsel for the petitioner submits that the power under rule under section 23 capital AA of capital AA within bracket capital AA 21 capital AA within bracket 1 within bracket small b of the Telangana Cooperative Societies Act 1964 can be exercised by the registrar
Lordship, may take it after 13.
we don't know after 1 week.
my lord,
He is
we want it only Monday, my lord. Your lordship may have it Monday, my lord, because it is a society having 7,000 members.
nothing is happening, Mr. Is there?
One second.
Is there? Oh, sorry. The IA2 is on record. So now you can argue.
May I make a
There's
suggestion?
no 13 today itself. Madam, delete this registrar and this thing. He submitted his submission and then, page 23. Page
23, madam.
Same thing, mister.
Same.
Same thing.
And now, madam,
He has only prepared from his vacate petition, so he will not refer to any other document. He will not say that, no, it's the same produced by appellant, your lordship may see that. He will only stick to page 23. Yes.
sir. Now your lordship may see the,
We never knew that the offices of village cooperative societies are so lucrative that people fight like this. Cats and dogs for this. Like, yes.
here, your lordship may see societies,
He is a society. Very lucrative. Brother says very lucrative jobs. Had I been in his position, GP's position, I would have withdrawn and issued a fresh notice instead of getting into all this. We don't know what will happen to his vacate petition. He may succeed also, but if it's rejected, then you are gone. Yes.
yes,
Yes.
madam, the page 23,
Registrar.
Roman 3, third column, Roman 3,
No.
page 23, top, madam.
Ah.
Roman 3.
Societies.
Yes, societies specified in rule 12A of the Andhra Pradesh Cooperative Societies Act 1964, and all other primary societies and societies whose area of operation extends beyond the district and whose headquarters is situated in the district, except societies under the administrative control of functional registrar. That your lordship may say, all registrar under the act, except certain sections which doesn't include 21WA. This is the power delegated to DCO. That is, your lordship could get on page 22 bottom. This is the power delegated to the DCO in respect of all the societies.
Then what is 1 minute? All right, we have understood. So why this entry has been made primary agriculture cooperative society separate entry?
16C relating to the employees, relating to the starting pattern of the employees. It is only
No. So you want to say if the notification, I mean, they could have made a reference here only. Why separate entries? So what, 1 minute, we want to understand, Mr. We are into debate, like we are not getting into membership of primary cooperative society, you know that. We only want to understand this government order. Why then it has been said, this thing, primary agricultural cooperative society, power under 116C. You say that it is governed under this Roman 3. So why then this, if it is governed by Roman 3, then this entry is redundant, right? This is primary agriculture is redundant because it has been dealt here.
yes, my submission, my lord, here in respect of the 2 primary agriculture cooperative society.
No, can the provision be superfluous? Because it says 116C also here also.
As I understand, my lord, here this is
We have understood, right?
only relating to the staffing pattern of the societies.
So therefore another separate entry.
That is
So
basic.
there should be 10 entries like one staffing pattern, one under 4.2, then one under 17, one under 18. So it's like this separate entries.
Ambiguity, it may not have been a very draft
Understood.
submission here.
So therefore you say, I mean, it's very short argument, right?
Yes.
That under this Roman 3, all powers have been delegated, which includes 21AA. Therefore, Deputy Registrar is competent to issue.
Except
1 minute. That's it. What did we have understood? This is the submission. What do you say?
Well, kindly see column number 2. It is only specified for primary agricultural cooperative societies. Primary agricultural cooperative societies only, my lord. Page number 20. Previous page. Page number 22.
Ah.
Only these are my society is a primary agricultural cooperative society.
No, what this entry relates to, we want to understand then why it is provided.
Society specified.
Saying that it has been provided. See, his purpose is to create confusion. You are a senior counsel, you should tell us why there is a primary agriculture cooperative society separate provision and what is the scope and impact of Rule 3.
societies specified in Rule 12A. That is what my land affairs says, that special Rule 12A Andhra Pradesh Cooperative Societies Act, all other primary societies which are operation extend beyond the district, whose headquarters situated at district levels.
Ah,
That's correct. Here is only, here is.
so you are, this thing is not beyond the district, huh?
That's correct.
Not beyond district. Petitioners is not beyond district, right?
Only confined to the district.
Ah, so be not beyond district.
That's correct.
And what is Rule 12A? Please tell us. Mr. Senior Counsel, which Rule 12A, what are these societies?
Just a minute.
Agriculture cooperative societies.
Yes, it's cooperative societies. Yes. It covers only in terms of section 19.
Okay, yes, it's rules. Yes, it includes petition of
No, no,
agriculture.
but which have operations, you will have to read this in the context. Having use operation or beyond the district. So if a PCS has more than one district, then
Then
it will fall under that.
All right.
That is why again, those they said. here,
This is Mr. A very simple answer, Senior Counsel. Class 3 applies in respect of primary agricultural cooperative societies whose area of operation is more than in one district. Respondent number 2's area is not in respect of more than one district. Therefore, class 3 does not apply. Correct?
That's correct. Correct. No, but kindly,
See, we have to formulate submissions for you. Huh? You only say like a judge, yes, right. We accept, I accept. We have seen that.
Read again, Melod. I'm sorry, but it is not only in respect of the societies.
1 minute, Mr. Let him. You have argued, we will hear you further if you are not satisfied.
It is besides the societies which are located, your lordship submit me.
1 minute, not. We will permit you. There is no question of not permitting. We want to understand what is his submission with regard to you have made.
Notwithstanding containing anything containing this act or rules made thereunder or bylaws of societies concerned, any other laws for time being in force which are the opinion of the registered societies. Majority of the shares had in which loan exceeding 50% of the total loan borrowing advances, liability by way of guarantee has been to the government.
This is C.
No bother.
This
Manufacturing other costs.
Not.
Start shall be from.
Like and should not be read as or. And be. And first is they are a cooperative society. Number 2 is both. And number 3, whose headquarters is situated.
Majority of the shares, not shares, 50% of the loan and initial liabilities.
So all conditions, 3 conditions must coexist in order to then only, otherwise this will be rendered redundant. Correct. It only says this. Yes. We have got it. Yes. What do you want?
Page 23, societies is specified in Rule 12A, the Andhra Pradesh societies, that means all the societies, whether it is district within which are allowed. And all other primary societies and societies whose area of operation extends. But the society within the district also is included, and the societies which are having the jurisdiction beyond the district also included. Right, societies within the district.
Therefore, what is DIPTI?
The district cooperative officer has the power of the registrar.
All right. Yes, madam. Right. Again, mark the presence. Petition is admitted for hearing with consent of the parties. The same is heard finally. In this petition under article, in this writ appeal. Oh. In this, then not petition, appeal. Next.
But that, your lordship have taken that the societies which are spread beyond the district alone, but he said all the societies under the districts.
That end cannot be read as R.
I'm sorry.
Where order has been passed.
There are other arguments. He wanted to clarify that. I'm sorry. I'm not interfering with the order of thought.
Can't interfere. Yes.
So we that said beyond the district, but it becomes agriculture, not primary. Primary is only confined to particular area.
So not covered, no,
Not
quite
covered.
well. Yes, madam. You write there. Where we have said, no, that it is covered by rule 12A. You say not covered by rule 12A. Huh? 12A of the rules. Not covered. Yes. Next.
May I please, Your Lordship? May I please, Your Lordship?
All matter 15. What SLP, that transfer petition dismissed?
Yes, Your Lordship. We have been informed, Your Lordship, we have to file a reply affidavit, Your Lordship.
Who has to file?
The petitioners, Your Lordship. I am for the petitioner, Your Lordship.
Counter has been filed.
Yes, Your Lordship.
Petition is admitted for hearing. Learned counsel for the petitioner. Praise for is granted 4 weeks time to enable him to file a reply to the counter filed on behalf of the petitioners.
Much obliged, Your Lordship.
Next. This is 15.
No. So this.
What is mandatory SURFACE Act? Madam SURFACE 13(3)(a).
Appeared for respondent number 4 minutes.
1. So you have not complied with 13(3)(a).
13(3)(a) has been complied, Manashi. It has been complied. It was
That-
brought, it was.
Complied?
It was, yes, Manashi. It is a
You have filed counter.
13(3)(a), Manashi.
You have filed counter.
It is not filed, but it is the second round of litigation my senior has been filed with this writ petition, Manashi. Earlier round of litigation is writ petition has filed.
No.
Administration said it was.
You want to file counter, you don't want to file, then we will proceed with the hearing.
Yes, Manashi. It is only thing, Manashi, I bring to lordship notice, Manashi. It was a earlier round of writ petition was filed under section.
No, you are we cannot force you to file counter. You are not filing counter, you are arguing the case. In that case, we will hear senior counsel first. And
File a counter or don't want to file a counter?
we will record that you don't want to file a counter and want to argue. We will decide it.
We will file it within a 1 week, Manashi.
See, again, we are telling Mr. Praveen Kumar, tell him that this process is not by invitation. Nobody's marriage is happening here so that we invite that please file counter. Please come and have bless.
Have it after next 1 week time, right? And I file for next week.
Petition is admitted for hearing. No, don't admit. You relax, right? There is a stay, you relax. You have also become like state government, right? You are a bank. You are a bank, no? You are a bank.
Yes.
You have also become like government that 1 year before I will not file counter in a writ petition, correct? Yes, Mr. Prabhat.
Lordships,
filed my reply, my lord.
Flood
have
victims,
been-
right? Flood victims.
Yes, my lord.
Well,
My lords,
Mr.
I request for the matter may defer for 2 days, my lords. We have received a reply affidavit from the
So,
council.
Mr. Prasad,
My lords, matter may put on for short pass, my lords, is on this.
short, you know, 1:30 till only 1:30 we
Yes, my
are.
lords.
Wait, Mr. Rao, we'll take it up the moment he comes. We'll finish.
Deeply.
In fact, lordships directed me to put
Ah.
tabular form.
You
that
have
steps
done this.
taken. What
You have
steps are-
done this, right?
Yes, my lord.
Ah.
Deeply.
Nice
Yes, deeply.
index.
Because in future, my lord, if the people will face anything, they will get benefit from this honorable court.
Definitely.
It is one and only temple to provide justice to the public at large.
Definitely.
Deeply, please.
Right, Mr.
All measures are taken, my lord, no rains are coming, my lord.
Hmm?
All measures are taken, my lord, for floods. No rains are coming.
No rain. No, the rain should come, but it should not cause any damage. That's what we can pray, right? Rains are necessary, but it should not cause any inconvenience to public. That's all.
Yes, my lord, that's
Let him come.
yes.
Entire July, heavy rains, flooding.
Ah,
Entire August, no rain.
ah,
It's drought now. All the cotton crops are.
that's what brother is saying, that July excess rainfall.
Yes, yes.
August,
Yes.
no rain,
But
cotton crop is good.
But one after 2020 June, my lord, every year facing the problem, my lord. That has been stated in my tablet.
So we hear.
Tabular form copy from the council. Tabular form copy.
They asked him,
He wants something.
That spiral binding.
Already he has received special GP, my lord, that copy. One more copy also I'll submit. Like for the petitioner in the matter, your lordship. Spill WP has been filed, getting to your lordship's notice, illegalities that has been committed in the CS14 matters, your lordship. The petitioner is a practicing advocate of this court.
Which case is?
Item number 17, WP bill.
that will be saved, this now that will be. Where the application. How will the future?
That is a personal dispute, CS. 1 minute.
Yeah.
Only we are trying to understand. You are a noble soul, nothing to do, an ascetic sense of detachment. Then, but that's a personal dispute between two parties, right? I mean, there no two parties. There may be several parties.
Yes.
At whose instance you are getting into PIL?
Yeah, just getting the.
No, just letting. It's very easy to say. What is the source of information that fraud is, if any fraud is being, 1 minute, if any fraud is being played, the council, the parties before us are competent to approach the court. Public interest litigation, what is the first requirement? You should say that people are so poor and they are illiterate, but they cannot approach this court. Therefore, I have 5 doctorates from various disciplines, and therefore I am filing the petition on their behalf. No, not there. No, so therefore it has to be dismissed.
The fraud is apparent on the face of the record by registered documents. They have filed.
No. Can we declare the sale deed to be void in these proceedings?
Yes, our entire endeavor is to get it before your lordship's notice. After that,
No. Acha, and who are you?
I'm a practicing advocate of the court.
So practicing advocate, what to do with the subject matter of civil suit? Minute. You have to, don't say like, do like this. You see, we are judges and you don't know, you have drafted the petition and have landed it and doing like this, waving to us. 1 minute. You haven't brought the case law. We are asking you pertinent queries in the context of law laid down by Honorable Supreme Court. You are saying law does not apply to, law declared by Honorable Supreme Court doesn't apply to me because I am an advocate. If we start doing like this, will you feel good?
My limited prayer, what I'm seeking is, I have given complaints to the department that may be considered in accordance with.
Nothing.
seeking a court mandated probe.
Nothing. We'll dismiss this petition.
Should I say my prayer for a moment?
No, you tell us, Mister, is there an averment that the parties, whose benefit have you filed this petition?
Just-
1 minute. Answer, whose benefit have you filed this petition?
State's benefit, Your Lordship. Then among the scale of stamp duty,
Subject matter
taxation,
between private parties and state is pending for adjudication before Honorable Supreme Court matters. Subject matter pertains to CS 14, abuse pet lands matters. Dispute between government and private parties.
He also wants to share in the property, that's PIL.
Government is the owner of the property matters. Owner of the property.
You should give him one property, free of cost.
They have no right matters.
Hey, Mr. Who are you? No, please sit down then. Please do not address. Please do not, you have engaged a counsel. No. We are discussing healthy things. We are not, please, you can. We are lighter side. We are saying things. You please, that's why petitioner should not. Please sit down. Please take your seat. We are saying things in lighter vein. This is not attributing any malafide. We will pass an order by assigning reasons. We are clarifying that we are not attributing anything to you. There's no certificate is needed. Every order goes to Supreme Court. Yes.
May I circulate the copies of the order for the Honorable Supreme Court matters? That's before the Honorable.
So, Mr. Please, now you argue. What is this public petitioner is an advocate? Then
Before the Honorable Supreme.
what is the this thing subject matter of this petition?
This bill WP is fine. If Your Lordship may see my prayer, Your Lordship may see my prayer from
Yes. What is the prayer?
page 7. Your Lordship will find my prayer. For the reason stated in
Page
the
1 minute. Which page?
7, Your Lordship, of the paper book. For the reasons stated in the accompanying affidavit, it is humbly prayed that this honorable court may be pleased to issue an appropriate writ or order, direction or more particular in the nature of the writ of mandamus, directing the respondents one to
Where are you reading? Here. Yes. Appropriate. Correct. Yes. Read.
to take appropriate action against the respondents 13 to 38, herein including prosecution as contemplated under Income Tax Act 1961, the Prohibition of Benami Properties Act 1988, the Companies Act and the Prevention of Money Laundering Act and the Prevention of Corruption Act in respect of income tax evasion, money circulation, Benami transactions, corruption arising out of the manifest real estate transactions, including such other acts or omissions, commissions which may come to light during the course of investigation, and be pleased to pass such a. The next relief what I am seeking is a court monitored probe, Your Lordship. For the reasons stated, it is humbly prayed that this honorable court may be pleased to pass an order, writ direction, monitoring the investigation being conducted by respondents so and so, relating to the illegal transactions between the respondents 13 to 38 mentioned in the petitioner's complaints. The petitioner has given complaints, Your Lordship, to the.
So one thing is, first prayer is direction to respondent number 1 to 12 to take appropriate action against 13 to 38. Prosecution under these acts,
Yes.
right? Correct?
Yes.
What is the
The
second
entry
prayer?
I am seeking in IX.
The only prayer. Acha.
Main prayer.
So, what is this thing, representation you have submitted, complaint you have submitted to?
Your Lordship,
When?
take your Lordships to. Lordships, I have given total 5 complaints, Your Lordship.
Huh?
I have given total 5 complaints to all the respondents. The first complaint, Your Lordships will find at page 184 in my paper.
Date.
Yes. Date is 28/4/2021.
28 4
2021.
20 2020
21.
21.
21.
Page
Page 184.
184.
Yes.
This complaint is made to whom?
Made to the. It is made to the Director General Anti-Corruption Bureau and the Director General Vigilance and Enforcement Department, who are one of the respondents here.
One.
The second complaint, your lordships will find at page 187. That's a comprehensive complaint which I've given to all the entire hierarchy of the income tax department along with the enforcement directorate and the SFI. Dated 24/5/2021 at page 187.
24/5,
2021.
21,
Yes.
1 month after. Yes.
And
Page 187, complaint to CBDT.
yes. Then the next complaint your lordships will find at
So what is this complaint about? Like first one is what, brief you can tell us, what is the gravamen of
your lordships.
your grievance in first complaint?
Your lordships may kindly take my writ affidavit. I've dealt in detail in this writ affidavit regarding what
First complaint, what?
lordship 184.
Just tell us, we will go through it. What, like first the complaint is about what? To DG, anti-corruption and this.
Taken place between the departments, so that's all.
Hmm?
I get for example, if I will say it like this here. I am a third party. I claim that I am in possession. I claim and I have invested money. I get 38 acres of land in a settlement deed. I have no.
38?
I am a third party here. It's you. I am in possession. The document says that I have made certain investments. By a settlement deed, I get 31 acres of prime land. I have no pre-existing title. It is a deemed sale which has been camouflaged as a partition deed.
So you have given instances of such irregularity. Who has done it? Like a
Have done it in
no, third parties, the respondents have done it.
yes.
Third parties, according to your complaint, respondents without fraudulently acting in collusion with somebody
Yes.
has transferred prime government land to 31 acres to someone without pre-existing title. This is first complaint. Partition deed. Partition means government has executed officers.
Third parties have executed in favor of third parties. People who are claiming.
They have recognized partition deed.
Yes.
And
They have no recognition.
please sit down. Sorry, will you argue?
May I assist, my lords?
No, please come properly so that he will sit down. We will hear you.
My humble submission is.
We want to understand. Please come and take this. Not here. Please go outside. We will wait, Mr. Sanghi. We will wait. Please go outside.
My
Yes.
humble submission.
Yes. First complaint is about
My
what?
humble submission is a property transfer from A to B.
Hmm?
If property is transferred from A to B,
Ah,
it requires a registered sale deed.
yes.
Here, A transfers property in the name of B by saying that B has pre-existing title in the property. And a partition deed is executed instead of a state
Between two private individuals.
between two private individuals.
In respect of a government property.
In respect of the property which is covered under CS 14.
So CS 14 is a government property.
Yes, no, CS 14 of private party.
Private. Acha. Partition deed. Good, 1 minute. If we understand, we want to understand. And Mr. Sanghi, don't feel offended. This all lighter when we tell. Don't say. Don't keep it. What we are clarifying. Don't keep it in heart. I mean, there's nothing like this. I don't even know you. I have just now learned that you are. Otherwise, you can understand that. So partition deed is executed between
But instead of sale, parties execute partition deed.
Partition deed in respect of private property. It is government land.
Private land.
Private land. All right.
The private land is worth around 1,000 crores.
All right.
Instead of executing the sale deed,
Ah.
whereby the vendor would attract income tax,
Ah.
and the vendor
Stamp duty, registration duty, all that is evaded.
income tax, capital gains tax,
Ah.
everything is given a go by. By camouflaging the sale deed as a partition.
And so this is evasion of
Division of income tax and capital gains tax on a humongous scale. Then a lot of kindly appreciate many
One.
transactions. It is happened to the naked eye, Bernard, because the person who's been transferred the property says, I invested some money in the property and I'm in long-standing position. Therefore, I'm entitled to an action. If I not to kindly take the partition deed to
fine. So
at page 489.
1 minute. So this is your first complaint.
Fine.
Evasion of the income tax and this all other dues. Ah.
By camouflaging a
Fine.
sale deed as a partition.
this is first complaint, right?
My lord.
Then
The other complaints are the registrars.
just briefly, we just wanted to just briefly tell us.
My lord, my humble
So we have
submission is
understood first. Second is 24th May 21. What do you say?
page 21.
No, he said 187, page 187.
My lord, 187.
Ah.
112. The second complaint, yes. My lord will find, this is the complaint regarding
Yes, second is 24th May.
My lord, my humble submission is, the other complaint is that the registrars have virtually abused their office by having registered properties for a song. The guard value of the property, which is called as the market value, based on which stamp duty is calculated, is later assumed that is 7 crores or 10 crores. They registered the document for 10 lakhs, 15 lakhs. And my lord's companies purchase properties.
So this is your second complaint that the registrars have registered the properties below market value. This is 24/5.
1% of the market value. And what happens?
Correct, correct. We are just understanding. We'll go to Mr. Sanghi. We are hearing on admission. So we just want to know the gist.
My lord, may kindly take page number 188.
So right, this is that registrars have valued below.
To draw my lord's kind attention to the list of companies. These are 40 companies. All these companies are having paid up capital less than 10 lakhs, 20 lakhs. And that is why they purchase properties worth crores of rupees by citing only 10 lakhs or 15 lakhs in the sale deed. The camouflage sale deeds as assignment deeds.
So these registered documents have been executed below market value in favor of these people.
Submission at 1% for a song.
Market value. Oh yes, for a song. Correct. Then second, this thing is what? Second
complaint is where the sale deed has been camouflaged as the partition.
This is 24/5, right? Second is 24/5.
Yes, ma'am.
What have you said in second?
But here, a partition deed, I have enumerated all the deeds in detail as to what has taken place. These companies don't even have paid up share capital. My humble submission is all these companies have paid up share capital of less than 10 to 15 lakhs. And the purchase properties worth crores of rupees. These are apparently Benami transactions. That, my lord, I have explained in detail. Assignment deeds worth 5 crores, valued at 10 lakhs. My lord, all these illegalities have taken place CS14. I am not for a minute on the properties. I am not for a minute saying that.
Of course, you are not a party.
I am not a party. I don't even care.
Yeah.
My humble submission is the state has been taken for a ride.
The third, this thing is.
The income tax department has allowed itself to be taken for a ride.
So third complaint is what?
165.
Third complaint.
At page 165, my lord.
Complaint dated.
31/5/2021.
31/5/2021.
2021.
Page
number 165.
16. What does it say?
My lord, regarding all these documents at page 169, my lord will find one document. At 169, I explained as to how the sale deed is fraudulently registered without any money having changed hands. My lord, my humble submission is
169.
yes. And then at page number 171.
169 is saying, yes, said about fraudulent
where a property worth 1 crore 3 lakhs is registered for an undervalued amount of rupees 10 lakhs. And where the property worth 7 crores 26 lakhs is registered for an amount of rupees 10 lakhs. Then my lord will find at page 174 also. I have explained in detail as to how my lord the exchequer has been brought of its dues. My lord will kindly appreciate one particular property, one particular transaction. The property is worth around 1,000 crores.
Instead of executing a sale deed, they execute a partition deed. The sine qua non for a partition deed is that the person should have antecedent title to the property. He says, I made some investment and I'm in long-standing position. Therefore, I'm entitled to 70% of the property. Without having any antecedent title. One person is getting 35 acres of land. It is a deemed sale under section 56 of the Income Tax Act. My lord will find the document at page number 489.
So this is your third complaint that sale deed referred to at 169 has been executed fraudulently.
My lord will find the document at page number 489.
489.
May I invite my lord's kindly to the said document.
Yes.
Deed of partition. This takes the cake as well as the bakery. Deed of partition through out of court settlement. That is the caption. At page number 493, my lord will find the relevant.
Yes.
The person who is receiving 37 acres of land, then under this document says, whereas the second and third parties also had incurred expenditure independently, and they are in possession of the scheduled property, and thus the dispute arose between the parties herein. As the dispute between the parties was aggravating and parties vexed with the litigation, intervention of parties have arrived at a consensus settling the so and so by executing the deed of partition. My lords, if these things are allowed to prevail, then what would be the rule of law in my humble submission? That is why I have taken a step of filing this petition before your lordship, seeking an incisive investigation as per the Vinitara ethics. Because if you do not monitor this investigation will go nowhere.
No, investigation has already been ordered.
And not at all. That is why I filed this petition.
So only thing is like two questions we have.
Yes.
Brother will also ask. I have one question for you, that all these questions, whether sale deed is fraudulently executed, whatever, will it not be argued in CS 14 and 7?
I leave it to my lord's kindly.
No, we are asking you as an officer of the court, we are asking you whether this question, right? So for this scope, this has two aspects, right? One thing is you are saying that the parties did not have any antecedent title. Despite that, they have executed the partition deed.
I would rephrase, my lord. My humble submission is,
I'm just broadly trying to. Instead of sale deeds, 1 minute. Instead of sale deeds, parties have executed partition deeds and have taken the income tax department for a ride, and including the government has lost its revenue. One submission.
Itself to be taken for a ride.
Right. Number one. Broadly speaking, that you can fine tune. Of course, we are not hearing finally. So this is for submission. Second is, you are saying that the sale deeds have been fraudulently executed. You have pointed out 489 to 493 and 169 to. So we are asking the issue with regard to one thing. So my question is, issue with regard to validity of the transactions in respect of which you have made a claim in the petition. Will it not be gone into in CS 7 and whatever 14?
Only in CS 14, your lord.
14.
Only in CS 14.
Will it be gone into or not? As an officer of the court, I am asking. If you are a big spirited individual and an officer of the court.
My lordship is a master of the rooster. My lords, if my lords are inclined to hear this matter along with CS 14, I would only like to clarify one thing is my humble submission. I am not challenging the transaction for a minute. I'm not bothered about whether the transaction stands, the transaction fails, or I'm not bothered about the validity of the transaction. I'm only bothered about the exchequer. The exchequer should have got his pound of flesh out of these transactions. That the exchequer has been deprived of. I'm not bothered because.
No, so is it your case that supposing the stamp duty or whatever charges due on partition deed have also not been recovered?
Nothing, my lord.
Still, partition suits are not finalized, your lord. There is no final decree in this case.
That's why. And another question is, Mr. Supposing if we entertain the writ petition, your petition, this is just a broad this thing. What impact it will have on CS 15 and 7?
Your lordship, there will be no impact on the case.
1 minute. You are the petitioner.
I am on behalf of the.
He's 14% is addressing us. He's 14%. Huh?
The transaction will stand. the deeds will stand. The parties will only be compelled to pay income tax and stamp duty and registration charges wherever it is required.
May I submit minutes?
So in respect of your cases, in respect of documents which have been executed,
My lords.
on that also the requisite duty is not recovered.
Nothing, my lord, my humble sir.
Partition did just like that.
My lord, that is why I've explained everything in detail regarding each and every transaction.
Yes, and 24 January, one.
The property, the transaction says the property is worth 7 crores. The agreement of sale, the agreement of sale itself says the transaction is for 7 crores. The registration for 10 lakhs. And my lord, the register goes on to record the market value on the back of the document.
On this, you are saying that this thing, it has been registered below market value for a song.
For a song, my lord.
Like market value of the property is how much?
My lord, the card value, my humble submission. The card value.
Guideline.
My lord, 7 crores, 10 crores, 25,000 rupees per square yard.
Then what has happened?
25,000 rupees per square
What has happened? They have done it for 10 lakhs.
10 lakhs, my lord. And the partition deed, my lord, is pertaining to an extent of 38 acres. Huh?
This is actually was mentioning something about this land. This is important. But June 28th or 27th, what is this into? This simple definitely a dispute between the party, government and party. So Sangeet, this state government has filed an SLP.
I beg pardon?
State government is in before the Honorable Supreme Court, claiming that it's their land.
Yes.
Now, if that happens, if tomorrow they are successful before the Honorable Supreme Court, saying it is a state government land and not any of the private parties. So whatever money they have paid goes down the drain.
My lord, there is your lordship.
No, we are only asking because you see, there is one judgment I am not immediately getting, but somewhere between 26th to 28th of June, the Honorable Supreme Court, these are government lands.
It is not government lands.
No, I am telling you, there is a judgment of his lordship.
I have a copy of the minutes.
That's what I am saying. It has been held to be a government land. Their private claims have been rejected.
That's what I want to submit your lordship.
Are you aware of this judgment?
Supreme Court of the civil stand.
Whatever is the judgment of this court has been overruled and it has been held to be a government land. Once it is held to be a government land, what is the effect of this?
This survey number has not been held to government.
No, CS.
Total CS 14 minutes.
14, I remember. That is why.
I would request one thing. Let them file a counter saying that this is government land.
No, please, you examine this.
Well, it's true. My humble submission is
May I submit another copy?
that judgment has many aspects.
We would like to, we don't know, please,
Request one thing, madam.
then we have to go through it if you don't want to, if you are, I don't know.
May I request one thing?
So we'll take it up after 1 week.
No. Let them file a counter.
No.
That will assist your, because let them take, let them make a commitment that the land is government land, that will be the end of the matter.
Will 15 June 2023 is the order has been division bench. I would like to go through it. I don't know. Yes, I to be tell you the truth, I haven't read it. This judgment, I would like to go through it and then pass. We don't want to do anything which will impede the decision in OS 7 and 14.
Request only one thing.
Yes.
Try to consider. Let them file a counter. Stating the land is government.
We will first see
That will
what.
be the end of the matter. Let them make a commitment before the honorable court that the land.
No, you also tell us that clearly that it will have no impact on decision of OS 14 and whatever CS 14 and 7, which is pending since 58.
Let me repeat myself. I am only concerned about the levy of stamp duty registration.
No, but you say that it will have, if petition is entertained, it will not result in procrastination of proceeding in OS. That's the only concern we
Let's
want.
take the argument to its logical conclusion.
Honorable Supreme Court observed that it's a civil scandal, my lords. The way it is adjudicated.
See this.
My lord, let us take
You are placed on record, right?
let us take the
We have-
argument. Let us take the argument to its logical conclusion.
No, we want to go, we told you that.
This is fine.
There is no, this thing. It's a public interest litigation, you are doing bona fide. There is no hurry, right, that today itself, they should go behind the bar, nothing. Yes, let us go through this judgment.
I will assist your lordship.
Yes, 13%, Mr.
Santosh Kumar, Santosh Kumar attached to the officer of Advocate General.
Has produced a copy of order dated
15th June 2023, my lords.
15 June 2023, asked in CA number. Civil appeal is not there. Asked in SLP C number 2373 bar.
Wait, please, my lord. I have filed, reply to the counter filed by respondent number 6, my lord. A file reply to the counter filed by respondent number 6, my lords. Cases pertaining to premature release of.
So you have filed reply.
Yes, ma'am.
So where is that reply? When did you file? It's not on record.
By US.
Learned counsel for the petitioner submits that she has filed a reply to the counter filed on behalf of respondent number 6. However, same is not on record. Office is directed to trace the same and place it on record.
Lordship,
List after 1 week.
Lordship, may I make a submission? In this matter, respondent 6 jail authorities have filed the counter.
She wants to.
No,
send a
recently,
reply.
one more we have filed.
She has filed a reply. She has filed a reply to your counter. Then you are telling us something which is. The problem is the counsel who has filed the counter says I have filed counter. The 1 to 5 do not say that we don't want to file a counter or we will rely on counter of respond. That is our problem. But in any case, you are saved from this because she says that she has filed a reply to the counter. The presumption is R1 to R5 do not want to file any counter.
R2, R3, R4, R6. On behalf of R2, R3, R4, R5. The 6 has been filed. That's, I want to make a submission.
Premature, he ran away from the jail. You ran away from the jail, madam.
Yes,
It was the good fortune of the authorities that they found you. And such a this thing convict who has run away from the jail seeks premature release. We are sure we will hear you. Yes. Next.
Much of it.
This is NCC. Mr. How many minutes you said yesterday?
I said 30 minutes, but that was 3 days ago. My lord said it's completely 20.
20 minutes. So we settled for 5 minutes past 1. See.
Yes, Lord, I will do my
lighter vein. It's not that we will hold you by this thing. The idea is otherwise we can't hear it.
Yes, I understand.
Yes. And we are sure that you have an excellent case on merits. That's why.
Yes, Lord.
If you can conclude within 20 minutes.
Yes, Lord.
Yes, please.
Wait, please.
My lord, I have filed the memo, my lord.
Yes.
My lord, on behalf of the NCC, my lord, I have filed the memo along with the documents.
Yeah. We will hear you, Mr. Praveen Kumar. Yes.
I have prepared, my lord, a single page list of dates and single page contentions.
Yes.
We are referring to 18674.
Hey, one minute, this one case we have to deal with the item 23.
Yes.
We will deal with it and then take up your case.
Yes.
1 minute,
Very good.
1 minute. File 23. Mr. Rao, yes. What is the IA you have filed?
We considered as a local candidate, my lord, all 8 petitioners, they have filed a counter, my lord, university.
Oh.
My lords may kindly take the counter, my lord. They have simplified.
So you want final hearing, right? Then
No, my lord,
you will
IA
have to get in queue or you want interim order.
IA3, my lord.
IA3.
IA3, they filed counter. But they have simplified my case. That's
Oh, good.
But paragraph 4 and 5, my lord, of the counter, university.
What are the facts?
My lord.
Completed in Russia, Ukraine, China.
My lord, all of them China,
Contract basis civil surgeon 12 to 18. Regularized as assistant surgeon on 18, 29/7. NEET PG. Validity of Rule 8 of Telangana Medical Admission Courses Rule. Local area. Following reliefs. Following orders passed on night. You have, Mr. Rao, filed the counter, no?
To the IA, my lord.
IA, not to the main petition.
Main also.
Main petition I filed counter.
No, yes.
Main also filed.
That.
This simplifies the
Then
case,
we,
my lord.
no, but we can hear, right? Why do you want piecemeal sort of thing? Same this thing, no?
My lord, here.
What do you want? Like piecemeal, interim order first, then.
But the difficulty of the petitioners was they were
No.
considered as non-locals.
1 minute, Mr. Rao. What we are trying to say is that we can take up this case for like after this case for final hearing, right? If not to today, on Monday.
I would just suggest that instead of going into the geo, if I'm considered as a local candidate, subject to, if I'm considered, then I will not have any complaint with the geo. That's the only simple. I challenged the geo. I had no option. The petitioners, they were being treated as non-locals. Now I have been restricted to only 20 colleges because of this geo. That's how I challenge the geo. If I'm treated as a local candidate, because being born here, studied here.
Like so, the issue is in this case is after 2/6/2014, 100% reservation for local candidates.
Yes.
This is.
Yes, I'm neither here nor there, my lord. That's how. Because I was considered as non-local even before that.
You are not neither in Russia nor in India. So somewhere between Russia and India. Lighter vein, Mr. People are so serious. You saw what happened in a public interest litigation where no stakes were involved. So that's why we are this thing. Humor in all the times, Mr. should be maintained.
Effort.
No.
Effort translates, my lord, in such a way, my lord. We put in effort. That's all.
No, good. No, but you.
Well, now the university has, my lord, cleared certain aspects. That'll, my lord, that's a clinch.
No. So you want a decision finally, right? Clinch the issue means petition should be then. NCC candidate is the first. This thing, his case is. We will take it up. Correct, Mr. Rao. We'll hear. Please wait and request your friend to conclude as early as possible. Mr. Rao will be brief. We are sure. Yes. Yes, please. What NCC candidate, Mr.
Lord, an amendment to the rules.
NCC and MBBS has nothing to do with each other, right?
Lord, but reservation.
Like
yes, for that matter.
I'm not facing before hearing. We are just saying.
Yes.
You will agree, no?
I
Broadly,
agree.
that NCC participating in Republic Day parade and becoming a doctor or shooting a goal has nothing common with whatever treating patients.
For that matter, children of armed forces personnel, they also no reservation is required to again pursue, my lord, going by the same analogy.
All right. No, we are just subject to hearing,
Yes,
right?
yes.
This is not a legal argument which we are making. It's just said broadly.
It has got nothing to do.
Yes, NCC. Yes, so you have done NCC courts
The challenge is to build an amendment.
by which provision for reservation has been deleted.
Yes. I have
So your submission is if that is struck down,
yes.
the reservation
Get
revised.
restored. Yes, restored.
Yes, go ahead.
I have given a small list of dates. Your lordship may
Where is it?
peruse that.
Where is it?
My lord, on 5/7, my lords need not write. I have given everything clearly.
Where is it?
Madam.
Delhi stock.
Yes, yes, yes.
Yes. So nice, Mr. Yes, go ahead.
My lord, on 5/7/2000.
These rules have been framed.
My lord, the rules have been framed. My lord, rule 3(4)(c), 3 Roman 4(c) provides for 1% reservation for NCC candidates. My lord, in August 2019, the petition number 2 secured NCCA certificate. The petition number 1 secured, my lord, in August 21. The notification for need was issued on 6/3/23, conducted on 7/5/23. Results declared on 13/6/23. After the declaration of results, if we go behind, my lord, after the notification was issued, the rule came to be amended on 4/7/2023. My lord, deleting this 1% reservation. My lord, this is challenged in next page, my lord, on these 5 grounds. These are the 5 grounds for challenge. One, my lord, legitimate expectation, my lord, is one ground that we are raised. Secondly, my lord, it provides no, my lord, grace marks to only 3 categories of persons who were earlier entitled. My lord, there were several categories of persons they were entitled. My lord, that is arbitrary, my lord, violation of Article 14. And my lord, the amendment seeks to alter the position which was existing as on the date of notification, subsequent to the notification and examination, which is impermissible. Then, my lord, the amendment has the effect of reducing the number of seats available under the NCC quota, which is, my lord, prejudicial. Finally, my lord, there is no rule 4. My lord, the amendment seeks to amend rule 4 on the question of ambiguity. My lord, these are the grounds that are raised. My lord,
yes, this is what we have been requesting everyone.
This is the long and short.
Yes.
Long and short of the case.
3 submissions and then you can now argue.
In 5 minutes, I have completed, my lord, the long and short of the case. That's my case.
Correct.
My lord, may I invite your lordship's kind attention to the earlier GO, my lord, only few provisions at page 16 of the writ petition.
61.
This was the one which was existing prior to the deletion of reservation. Page 16 of my writ petition.
16.
1/6, my lord, page 16.
Yes.
This is GOMS number 75 dated 8/9/2015. My lord, the government, my lord, amended the earlier rules. That is 114 was also amended. And my lord, the priority is given, my lord, to several categories of persons who are entitled for, my lord, that 1% reservation. So you may kindly see those priorities, my lord. Priority 1, NCC candidates participating in international events selected for so and so. NCC candidates participating in international events in shooting, sailing, rafting. Then NCC candidates, the winners of gallantry, so and so. Priority 2, my lord, medal winners in Republic Day camp at NCC at any event at New Delhi. The lordship may kindly see 2A. It does not require it should be an NCC candidate. My lord, the rules earlier.
Yes.
But the rules earlier, priority 2A, your lordship may kindly peruse. Medal winners in Republic Day camp at New Delhi in any event.
Yes.
Priority 2A, it provides for medal winners in Republic Day camp at New Delhi in any event. My lord, this is not restricted to only NCC candidates, meaning any person who is a medal winner at Republic Day camp, my lord, is entitled. Then, my lord, NCC cadets participating at Republic Day camp, that is B. Thereafter, my lord, medal winners in All India, Scenic camp, Nava Scenic camp, and Vai Scenic camp for Republic Day banner competition. Then participants, my lord, then my lord, E. 2E, my lord. These are all various, my lord, sports which are conducted by the respective federations and associations at the national level. The medal winners is E, participants is F. Thereafter, National Integration Camp, Andaman Nicobar Islands, so and so. Then priority 3, my lord, participants at Republic Day parade at state level. Participants at Independence Day at state level. Then finally 3C, my lord, provided for CBA certificate holders. At page 17, my lord, NCC certificate holders, priority 3C, provided for CBA certificate holders. Then, my lord, your Lordship may also see note 5 at page 17. The above priorities will be given to certificates acquired if the candidates represented through NCC only, and the same to be endorsed on the certificate. This, my lord, was struck down by division bench of this court. My lord, right now we need not be restrained by that.
8915 was
note 5 of page 17 was struck down. That is, my lord.
Where? Which petition?
I will just give the petition number, my lord. The fact of the matter is, my lord, it is not necessary that only an NCC candidate must have participated in this. Only even a non.
So you are trying to say that 89.
It's only for
1 minute. Yes. 89 2015. This sort of a priority, etc., was rightly provided, which has been deleted arbitrarily.
No, my lord, that's not what I'm submitting. I'm submitting, my lord, rule note 5 came to be, my lord, struck down by a division bench of this court. And, my lord, what is provided under 3C is now taken away, and a new category of persons is introduced. 3C. Priority 3C may kindly be seen at page 17.
3C. BC, Priority
3C gives to certificate C, B, and A certificate holders.
C taken away.
This, my lord, is sought to be now altered.
Altered means it is deleted, right?
Completely deleted. The whole thing is, but not whole thing. I don't understand what it means.
Priority 3C.
3C gives priority for certificate holders of C, B, and A certificate.
Republic Day certificate, participant Independence Day, and this
C, B, and A certificate holders. No, it is what is provided is under priority 3C. Certificate holders of C, B, and A are entitled, my lord, to claim reservation. Now, my lord, kindly see the amendment at page 19.
Page
19.
Yes.
Paragraph 2 of this amendment is subject matter of challenge in the writ petition. Your lordship may kindly find that at page 21. In rule 4, after clause 3 and the paragraph thereunder, the following clause shall be inserted, namely 3A, grace marks for NCC candidates. Before we see what is inserted, may I invite your lordship's kind attention to the rules, my lord, at page 38.
So how one thing you could have done was how it would read after this inserted and this thing.
Very well, I will read that. Page 19. Kindly come to page 21, my lord. NCC cadets who have obtained NCC certificates prior to qualifying exam, intermediate or equivalent, who have qualified NEET UG and who have applied for admission shall be provided with grace marks to be added to NEET score as follows.
So we got it like NCC A and C is left out.
It is gone. Yes. Here the petitioners are holders of NCC A certificate.
A and C is left out.
A and C is left out. C, my lord, may not arise because C, my lord, is something which you obtain after intermediate.
Earlier it was given.
Here it is A.
Earlier A, everything was there.
Everything, yes. There are many categories.
C, B and A.
Yes.
So this thing, your grievance is insofar as A certificate, because all petitioners are A certificate.
Yes. Yes. And A certificate holders are left out.
The fact is C also has been left out.
C may not be relevant. C may not be relevant because C, my lord, is attained after you have intermediate. So, my lord, for undergraduate courses, intermediate is, my lord, is the qualifying examination. So, my lord, there is no way they could have obtained C. So, there is no. My lord, is
all right, so we have understood.
Yes.
Now
may I invite the lordship's kind attention to the rules, my lord, at page 38.
Which rule?
Rules, the 114, the admission rules framed by the state, which my lords have been, my lord, looking into
Yes, yes.
for quite some time now.
Yes, now. We are very familiar with
Yes,
clause
my lords are
3.3.
more familiar. than we are.
No, 3.3b.
Yes, yes, my lord.
Yes.
My lord, the admission rules begin at page 38. Lord, should may kindly see after the word notification in the middle and after para 3, these rules may be called Telangana Medical and Dental College Admission Rules 2017. This is where, my lord, the rules begin. Rule 1, my lord, is definitions. Rule 2 is words and expressions. Rule 3 is eligibility criteria for admission. 3.1, 3, 1 second. Yes. Yes, my lord. Rule 3, Roman 1, 2, 3, 4, my lord, is at page 42. Horizontal reservation of seats. So rule 3, 4C provides for NCC 1% reservation. But my lord, the amendment seeks to amend a rule which is not existing. That is one of the grounds, my lord, that we have raised. Rule 4.3. They want to amend rule 4.3. There is no rule numerical 4. There is no clause Roman 3.
Where is the amendment?
Amendment page 21. Paragraph 2. Ambiguity is one of the grounds that is challenged. That is ground E. To understand, my lord, the mind of the executive in amending, may I invite your lordship's kind attention to C at page 21 also, my lord. In sub-rule Roman 5 for clause E, the following shall be substituted. My lord, there, my lord, they have removed NCC reservation. The rule, my lord,
No, so one of the arguments has, which you, perhaps you can argue that there is no deletion of this provision for reservation of 1%.
the court holds that.
No, this is what they are arguing, that there is no deletion, therefore they are bound to give me reservation.
Exactly, my lord, the question posed by the division bench while granting me the interim order. This is what division bench said. There is no amendment. The learned government period for my lord said that it's a mistake we have committed. He admitted, my lord, but it was not recorded in the order. But that's what, my lord, fell from the honorable bench. I am obliged. Now, my lord, your lordship may kindly go to page 43, where 5E is there.
43.
43, my lord. 5E. Reservation for special categories. Where, my lord, numerical 2 provides for national cadet 1% reservation. This is amended at page 21, removing, my lord, NCC. There, my lord, they understood Roman 5E correctly.
Where remove?
My lord, removal is at page 21. Page 21, paragraph C. Paragraph C. In sub-rule Roman 5. For class E, the following shall be substituted. There are 3 categories. Of 5, my lord, 3 are substituted now.
Clause E.
Yes. So they understood this correctly. Roman 5E, they have amended. There is no rule 4. There is only 3, 4C. Now, my lord, my main submission. My lord, the students, my lord, who had obtained the certificates, as on the date of the notification, my lord, under the rules, they are entitled for their certificates to be considered for 1% reservation. Even after the exams where results were declared, they were entitled. After declaration of results, my lord, the rules came to be amended. Your lordship has seen, my lord, in the list of dates. Therefore, my lord, a legitimate expectation which would rest, my lord, in the petitioners, my lord, is now thwarted by the amendment.
Rules amended after process began.
Yes, after the results were declared.
Results of NEET UG declared.
Yes,
When, can you tell us what, when was this thing amendment and this thing?
amendment. was Examination.
7/5/23.
7/5/23.
NEET examination. Mr. Rao.
It's there in the list of dates.
Then rule amended on.
Around 4/7/23. Exam declared on 13/6/23.
Result declared on
13/6/23. So
therefore has a legitimate expectation that
yes,
we are A certificate and therefore will be given.
Yes.
Correct.
I rely on latest judgment of Supreme Court rendered in July 2023. I'll just pass on a copy. The case where the Kerala Judicial Service, the full court took a decision that the recruitment for the post of district and session judge, which provided for written examination and interview, viva voce. And there was a minimum cutoff mark for viva voce. After the examination, the full court took a decision and introduced cutoff mark even for viva voce. There, the Supreme Court said that this is impermissible. The rules which existed, and there is a legitimate expectation of those candidates with respect to exam who have passed and who have secured the minimum marks. For this also answers the question with respect to policy decision being challenged, as violative of Article 40. May I invite your Lordship's kind attention?
What happened to the judgment SLP file? Not
this is the Supreme Court 5-judge decision,
No, you referring to Kerala judgment, right?
That is at page 1 of my compilation. Which
So you referred to Kerala, no?
I have referred what happened.
That's why we asked what happened to Kerala. It's attained finality.
It attained finality by a 5-judge constitutional bench of the Supreme Court. That is the judgment placed at page 1.
So then why to go to Kerala High Court?
No, I have said the facts of the case as to what has happened. Supreme Court do a distinction.
No, so what is the proposition that on the basis of on the strength of doctrine of legitimate expectation, a provision providing for reservation cannot be deleted after the process has begun.
I would say, even
no, we were trying to because it's not so stated here.
Yes.
So we are trying to understand from you so that so you say that once the process has begun, because it's not here, process has begun, the legislature cannot delete a provision this thing providing reservation, correct?
The doctrine of substantive legitimate expectation is a right in the participants.
Which judgment? Which
page 1? We will begin at para 18. Subject.
I think it's like this.
At page 10
So the remaining to remain articles, remaining to remain then this file will continue. So they are excluded as only subscription. Subscription is only in respect of subscription special categories. And restricted this holds. Treatment of traits. So, NCC recovery for the totally.
Yes.
But para 18 at page 10.
Para
18.
18.
Yes, at page 10 of the compilation. Running page 10, handwritten page numbers. The basis of the doctrine of legitimate expectation in public law is founded on the principles of fairness and non-arbitrariness in government dealings with individuals. It recognizes that a public authority's promise or past conduct will give rise to a legitimate expectation. The doctrine is premised on the notion that public authorities, while performing their public duties, ought to honor their promises or past practices. The legitimacy of an expectation can be inferred if it is rooted in law, custom, or established procedure. Para 29 at page 13 may kindly be seen.
No, we want that proposition which just now you said.
Yes.
Para 29.
Para 29 at page 13.
Yes.
Well, since this is a constitutional bench judgment, I need to show 2-3 more paragraphs.
Please.
A claim based on the doctrine of procedural legitimate expectation arises where a claimant expects the public authority to follow a particular procedure before taking a decision. This is in contradistinction to the doctrine of substantive legitimate expectation, where a claimant expects conferral of a substantive benefit based on the existing promise or practice of the public authority. The doctrine of substantive legitimate expectation has now been accepted as an integral part of common law as well as Indian jurisprudence. Para 41 may kindly be seen. In fact, my lord, what is the extent, my lord, what is the limitation of legitimate expectation is also dealt with. Para 41, page 16. The doctrine of legitimate expectation does not impede or hinder the power of the public authorities to lay down a policy or withdraw it. This is exactly what my lords have posed. The public authority has the discretion to exercise the full range of choices available within its executive power. The public authority often has to take into consideration diverse factors, concerns, and interests.
This is all in the exercise of executive power.
Yes.
This is statutory. The rules cannot be amended. This is the proposition we are looking for.
This is also not statutory. The rules have been amended here.
No, statutory. Yes, in exercise of statutory power under the Education Act. The rules have been framed.
Yes.
Rules have been framed in exercise of executive of the rule making power conferred under the Act. They have been amended in the like manner. This all legitimate expectation, etc., choices available within its executive power.
Yes.
We want to understand is whether the doctrine of substantive legitimate expectation will prevent the legislature from exercising its power under the rules.
Perhaps will not be stretching too far. I wouldn't.
But this is the case.
But that's not the case here. That's what I wanted to submit.
No.
Law of the legislature that was challenged. I will take 2 more paragraphs, then my lords would. The full court decision to amend the
rules, the medical rules are under the Education Act.
Yes, my lord.
Correct?
But under the Capitation Fee Act 1983, not under the Education Act, my lord. Your lordship may kindly see how the rules have been enacted. Yes. Capitation Fee Act 1983, which was adopted in 2016 after bifurcation for Telangana. So under the Capitation Fee Act, my lord, under section 3 and 15, the rules have been framed, which now have been amended. Not the amendment power is also traceable to the 1983 Capitation Act.
So this is not an executive power. What we are saying that these rules may be termed as rules, but they are not in power, exercise of power under Article 162.
The principle which is laid out by the 5-judge bench of the Supreme Court,
So you understood, no?
Yes, I understood.
Supposing if it would have been exercise of powers under Article 142.
Yes.
Then probably doctrine of substantive legitimate expectation would have prevented the government or university from this thing withdrawing on the promise of representation made.
Yes.
But our query is whether the same principle will apply in respect of exercise of a legislative power. And which paragraph Supreme Court says that the legislature also cannot enact a law in contravention of less substantive legitimate expectation.
That is not my submission. That is not also the case before the constitutional bench.
May not be the case, but we are deciding the case here.
here, the question, my lord, is.
No, again, we are this thing, as we have understood, please correct, feel free to correct us.
Yes.
We have understood that the rules are statutory in nature.
Yes.
In exercise of powers conferred under the Act.
Yes.
Those statutory rules cannot be amended by taking recourse to an executive order.
Yes.
That is not an executive order. So again, amendment is by statutory, in exercise of statutory power. So therefore, the question arises whether such an amendment, can you argue that on the basis of substantive legitimate expectation, the legislature could not have amended the rules?
There is no legislative amendment brought in the respectful submission in a case before your lordships. What is there, my lord, is the executive
are amended.
Yes,
flow only from the act.
But the delegated legislation draws its power, Lord, from the statute. Not the legislature. But my lord said.
You understand, right?
No. I cannot.
No. So therefore, the provisions of the Act are there under which it has been. So see, we are being clear to you by putting our doubts so that you can explain. You are saying it's not my case. Then end of the matter.
No, my lord. What I am supporting.
Your answer is it's not the case before Constitution Bench. We will write. It's not the case before Constitution Bench of Supreme Court. Therefore, that decision does not apply. There is no question of reading.
I am in fact relying on this decision. But that's why I need to.
Then please tell us how this decision, which paragraph Supreme Court says that the competent legislature cannot enact a law.
It doesn't say in any paragraph. It doesn't say at that aspect. It doesn't say.
All right.
But para 17. I was reading para 41 at page 16. The doctrine of legitimate expectation does not impede or hinder the power of the public authorities to lay down a policy or withdraw it. The public authority has discretion to exercise the full range of choices available within its executive power. The public authority often has to take into consideration diverse factors, concerns, and interests before arriving at a particular policy decision. The courts are generally cautious in interfering with the bona fide decision of public authorities, which denies a legitimate expectation, provided such a decision is taken in the larger public interest. Thus, public interest serves as a limitation on the application of doctrine of legitimate expectation. Courts have to determine whether the public interest is compelling and sufficient to outweigh the legitimate expectation of the claimant. While performing a balancing exercise, courts have to often grapple with issues of burden and standard of proof required to dislodge the claim of legitimate expectation. So, my lord, burden, my lord, is on the state. My lord, the Constitution Bench has dealt with that. Your lordship may kindly go to paragraph 43 of page 17. The principle of fairness in action requires that public authorities be held accountable for the representations, since the state has a profound impact on the life of citizens. Good administration requires public authorities to act in a predictable manner and honor the promises made or practices established, unless there is a good reason not to do so. In so and so held that the public authority should objectively justify that there is an overriding public interest in denying a legitimate expectation. We are of the opinion that for public authority to frustrate a claim of legitimate expectation, it must objectively demonstrate by placing relevant material before the court that its decision was in the public interest. This standard is consistent with the principles of good administration, which require that state actions must be held to scrupulous standards to prevent misuse of public power and ensure fairness to citizens. Now, Millard, the state, Millard, none of the counters, Millard, they have even dealt with any of the grounds that we have raised. NCC, Millard, only says that we have taken a decision.
First is over. That legitimate expectation.
Second is, I am showing para 43. I only wanted to impress upon your lordships that none of the respondents have made any effort whatsoever to satisfy this court. What is the larger public interest to keep out certificate holders from the whole thing. I could understand if they were also given some grace marks. There is no rationale whatsoever between the action and the object that is sought to be achieved is my respectful submission. Paragraph 47, I will show your lordships directly to the conclusions at paragraph 60, page 22. The following are our conclusions. The following are our conclusions in view of the above discussions. The principles of good administration require that the decisions of public authorities must withstand the test of consistency, transparency, and predictability to avoid being termed as arbitrary and violative of Article 4. An individual who claims
47 in a constitutional system.
I am extremely sorry, Bharat. In a constitutional system rooted in the rule of law, the discretion available with public authorities is confined within clearly defined limits. The primary principle underpinning the concept of rule of law is consistency and predictability in decision making. A decision of a public authority taken without any basis in principle or rule is unpredictable and is therefore arbitrary and antithetical to the rule of law. The rule of law promotes fairness by stabilizing the expectations of citizens from public authorities.
Yes, please.
Paragraph 60 is the conclusion at page 22 of the compilation. The following are our conclusions in view of the above discussions. The principles of good administration require that the decisions of public authorities must withstand the test of consistency, transparency, and predictability to avoid being termed as arbitrary and violative of Article 14. An individual who claims a benefit or entitlement based on the doctrine of substantive legitimate expectation has to establish the following. 1. The legitimacy of the expectation, and that too, the denial of the legitimate expectation has led to violation of Article 14. Public authority must objectively demonstrate, placing relevant material before the court, that its decision was in the public interest to frustrate a claim of legitimate expectation. 1, 2, 3 are relevant for the law laid down. Subsequent paragraphs are in the facts of the case, which may not be relevant for present inquiry.
Yes.
All right. Now, my lord, the only justification, I must say, provocation to amend the rule, which the state claims, my lord, is a letter which they have received from the Raksha Mantri of the central government, saying that there must be uniformity all over the country. So please allow, my lord, this. May I request your lordship to kindly.
That's why we were wondering why Mr. Praveen Kumar is repeatedly saying, I will file and this thing.
Yes.
This is the.
That's why. The only thing, my lord.
Yes. Yes.
I see, my lord, the letter filed by.
No, so what letter, what they have said?
That only one letter I'll show to your lordship, my lord, then.
Where is that?
That would. If my lords have got the memo filed by Mr. Praveen.
I have filed,
Get, madam.
In my case only, my lord, he has filed a memo.
Get this
start from
page 3 of that
page 3.
memo, my lord. This is a letter written by the Minister of State for Defence, Government of India. The lordship may kindly note the date, my lord. Page 3 of this memo. Date is 2nd August 2016. Page 4, my lord, they say the state government union territories may either provide grace marks to NC cadets for admission to professional colleges. Page 4, my lord. Paragraph A. State government union territories may either provide grace marks to NC cadets for admission to professional colleges or at the time of employment or at the following scales. NCC C certificate.
Yes.
NCC C certificate is Roman 1, which may not be relevant. 2, 3 and 4, they say participation, whatever is now included in the amendment. This is what is suggested by the Raksha Mantri. Therefore, we have done this. Is their case. If my lords have noted the date, date is 2nd August 2016. This is the date which forms prior to the rules, my lord. 2017 is GMS 114. This was in existence even prior to the framing of rules, which provided for 1% reservation. So now, my lord, it is in view of the constitutional judgment, it is the bounden duty of the state to place material before your lordship to show as to why in the first place they started with this 1% reservation, created a legitimate expectation. They are falling back upon government's letter prior to the framing of the rule, and then once again altering this, my lord, which, my lord, according to me, they are not discharged. Of course, after they argue, my lord, I will make submissions. On the question of, my lord, mandamus for policy, my lord, I have not, though I have placed judgment before your lordship, my lord, on the question whether mandamus would lie on the question of.
No, you are not seeking any mandamus. You are seeking.
I'm only seeking.
See, if this amendment deleting is struck down.
Yes.
The position revives.
Yes.
Correct.
Anything else, my lord, I'll submit in reply.
No time.
After lunch.
Today is Friday.
There is no bench.
Monday, my lord. We will. That's it.
Yes, madam. Mark the presence. Mr. P.S. Rajshekhar, Learned Counsel for the petitioner, has concluded his submissions. However, on account of paucity of time, which is IA number? Mr. If you do like this, Mr. C, if you prepare a synopsis like this and the way he has argued in 15 minutes, perhaps we can conclude your submission instead of interim relief and this thing.
Yes.
You consider that?
Yes.
So this also, what is your number? Item
23, Bala.
23, heard in part list on Monday before a bench in which justice
Your lordships kindly. With your lordships kindly. Yeah. I am item 19. While adopting the same arguments of my friend, IA 3 is
19 to 22 and
19. Yes.
19
Item
to 22 this order and 23 also separately Mr. Rao's case. Mr. Tirumala Rao. It's so pious name, Mr. Rao. Yes. So we hear you. Like these people will be brief, so maybe we can sit a little extra and conclude. We see how things go, right?
Yes.
If it's not concluded on Monday, we will at least try to commence hearing in your case on Monday.
Yes.
And continue if Tuesday also. You think about it, whatever choice is yours, whether to argue on IA or only.
I'll be precise, my lord.
Better, because now your cases that you are falling under the in view of that thing as local candidate.
Yes.
Let's see.
I'm taking shelter under your lordship's judgment, my lord.
You don't know.
Local judgment, my lord.
No, you
reported widely all across the nation now, Lord, this judgment in this context, my lord. Difficulty arises, my lord. Many states.
It's what? Yes. So, 4th September at 4:15, we conclude this this case first and begin your comments.
One request. IA 3 in item 19, 22. Item 22 may be allowed. This is seeking implement of NCC as a party respondent. I don't think, since it is the NCC which has.
Mr. Ravi Kumar, no objection. So then this item number 22, in addition to whatever has been written common order, you write IA number 3 of 23 filed in WP 22182/2023 is allowed. Let necessary amendment be incorporated in the cost title during the course of the day. Mr. Praveen Kumar accepts notice.
My lord.
Deputy ASCI accepts notice on behalf of newly added respondent. Then that order, common order comes, and then 4th September at 4:50.
Detail.
Number 16, they have it on Monday.
Monday,
Yeah,
of course.
Monday.
Yes. So on, Mr. Prabhakar.
My apologies, I was not there.
No, good thing about him, Mr. Prabhakar, what we like is that you will see always a smile on his face. That's what is very good.
Always been so many.
List on account of paucity of time, matter could not be taken up. List on 4th September 23.
Deeply oppressed. I'm deeply oppressed.
Lunch motions, Mr. Rao.
5 lunch motions.
5. Yes. We sit to the
Lunch motion, madam.
So we will assemble for lunch motion after another division bench, and if after I finish my single court, this single bench.
Not coming the lordship's way, but at 1 o'clock they are constructed and the airport.
They already completed. That is over, already over. That is already over.
That is the difficulty, my lord. See,
Then they will be considered, if the direction is given, they will be considered the third round of counseling.
third round, I lose a chance, but because already I lost it in the first round.
They came in delay.
Very brief manner. I am a local candidate as per the rule, as per your lordship's order also, I'm a local candidate.
Let's, Chupal, then, if you can't wait for 3 hours, then we have to sit. Mr. But senior counsel said invited me, please excuse me, right, for not making on time. Whosoever is there, I am requesting senior counsel. They had invited me today at 2, but we are sitting, so I'll be late. Please tell the Advocate General and other senior counsels that we are sitting here. They had called me at 2 o'clock. I won't be able to, slightly late, right? Please tell them. Yes.
My reflection number.
Yes. Mr. Senior Counsel, I was.
Second lunch motion.
No, that's correct.
Yes, sir.
So you are concerned about your case. We are concerned
Yes,
invitation to the. So like if you make me wait, sit till 2 o'clock, I cannot come to your bar association at 2 o'clock. That's what I am saying. And you are, so you will tell that we were holding him back on the bench and therefore he should be excused not being punctual. Correct, Mr. Senior Counsel? Correct?
Your lordship, sir, I
You will say, no.
cannot take 5 minutes because all covered
All
matters.
of them are covered.
Covered matters by your lordship's judgment.
They are not covered. They are not. Each case has to be dealt with.
Yes.
But I appear, my lord, sir, in this matter. The case, my lord, where I am being treated as a non-local. My treatment as non-local, my lord, is reflected at page 17.
When you were treated as non,
I was treated as non-local, my lord, not
on when?
first provisional list, my lord.
When? Date?
2/8, my lord, 2/8.
2/8. So what did you do for 1 month? Enjoying things,
No, my lord, in fact,
enjoying life, and then wait, when sitting, seeing what other peoples are up to, then come at the 11th hour lunch motion. Don't permit the judges to have lunch. Lighter when, Mr. We are this all these, Mr. Why with this? It's not that you very often think that the court is making irrelevant remarks. It's not irrelevant. No, we are telling you why. Why this? We said all this because we have denied the relief to a person who came with 9 days delay in such a case, and the Supreme Court upheld our order. In that context, you will have to explain 2/8/23 non-local rejected what till today, 1st September 93, what were you doing?
It's a fact that there is a delay. But I have to accept that. But
Then
I'll have
whether,
the bona fide.
1 minute, 1 minute. If there is a delay, every day's delay in such case matters. Otherwise, like we can understand, you can file a petition within 1 year, 2 year, 3 years also. Not there is a judgment of Supreme Court that supposing if a cause of action to prosecute a suit is 3 years, normally a writ petition filed within 3 years should be treated as within limitation. But these cases deserve a different treatment where everything is time bound.
That's true.
So what were you? You were then sitting, watching the result of those all people had come to the court within reasonable time and were diligent. That is the distinction. We will not grant a relief in exercise of Article 226 to a person who is indolent and sleepy.
In light of that, in fact, the lordships should kindly see, I'll only stick to the issue. I'm supposed to be treated as a local in this matter. That,
we can at this point of time say that they will consider your claim for being local if he is found. They will decide. We will not.
In the second round of counseling, because already difficulty is first round.
Difficulty is that you are sleeping.
Yes, Mr.
Please understand, this is the best we can do. Say second round, third round. We can, Mr. Please. It is open for us. I am telling you. That's why we said that if 9 days delay, relief is denied, upheld by Supreme Court 1 month. We can very well dismiss saying that no explanation for delay of 1 month, indolent person, no relief under Article 226 dismissed. But despite because Mr. Rao is so magnanimous that he said, I will consider. So we will, better you go. Representation only yesterday, Mr. Given.
Because the order was made widely public, in fact, I went yesterday.
Which order public? Rejecting your non-local.
My lords have decided. Yes, that order is made public.
No.
It's on the web portal.
No. Which order, Mr.?
Your lordship's order. My lord's your lordship's order.
No, so that doesn't depend on this thing. It's still the law that you are indolent. Whatever it is, Mr. Shall we dismiss the petition or you want a direction to consider?
Direction to consider in today's second list, because today is the last day, Millets.
No, this way we cannot set the clock back, Mr. What can be done?
Next list.
31st of next round of counseling.
Next round of counseling.
Yes.
Because I approached, in fact, I was supposed to make a submission.
Mr. 31st of August, you have submitted a representation. Please understand. This, we cannot force them to set the clock back. Like when that's all time bound. You knew when your colleagues, like your students like you, came to the court and were prosecuting, what were you doing? Tell us. No explanation, obviously. Then it was widely made known. Then you widely rushed to this.
I have too many. Only on the point of my bona fides.
At this point of time, nothing. No, this is the best thing.
Next round, Millets.
In this writ petition, in this writ certified copy today. Today. We don't want to give you relief, Mr. Because we told you.
After the order was.
No, it's very easy for me. We are making a departure from the view taken in Karnataka High Court. I am making a departure because of your submission. Otherwise, if you ask us to decide, we will dismiss the petition saying that 30 days after you have filed, delay disentitles a person under Article 226, and delay of every day in such academic matters counts. Therefore, dismissed. It can't be like that order is so everybody will now keep on rushing, saying that I am a local candidate.
Yes, sir.
Mr. Rao will not entertain such a claim. This with consent of the parties, the matter is heard finally in this writ petition, the petitioner inter alia seeks a direction to petitioner to treat him as local candidate. Paragraph. Admittedly, the petitioner was declared as a non-local candidate on 2/8/2023. The petitioner thereafter submitted a representation to the university for the first time on 31/8/2023 and has filed this petition today, that is on 1/9/2023. There is no explanation has been furnished for inaction on the part of the petitioner for a period from 2/8/2023 till 31/8/2023. Full stop. Paragraph. The second round of counseling is already over. Full stop. Paragraph. In view of Mr. Rao, delete on Mr. Learned Counsel for the petitioner as well as Mr. Rao jointly submit that the second round of counseling is over today at 1 p.m. Full stop. 1 p.m. The matter is being called at 1:40 p.m. Full stop. Therefore, Learned Counsel for the petitioner submits that the university be directed to consider the claim of the petitioner as a local candidate in the next round of counseling. Mr. Rao, Learned Standing Counsel for University fairly submits that the claim of the petitioner shall be considered as local candidate in the next round of counseling. Paragraph. In view of aforesaid submission and in the facts of the case, petition is disposed of in the direction that in case that the claim of the petitioner for being treated as local candidate shall be examined by the university in the next round of counseling, which may be held for admission to MBBS/BDS course. It is made clear that this court has not expressed any opinion on merits of the claim of the petitioner. Accordingly, petition is disposed of. Certified copy today.
Deeply overlooked, perhaps.
Yes.
Subject to your lordship's similar. A similar direction may be carried out.
All right. Same order?
Yes.
Same order.
But representation waited today. Representation is 1/9. Yes, only that.
Representation has submitted today 1/9/19. Same order, madam. Disposed of. Certified copy today.
Public.
Yes.
Petition lawsuit, the petition after the B category lawsuit, the management quota, C category is not made up.
Management is very generous. Which page?
He has not included the order copy.
No.
Order copy is only to consider the representation.
Consider. Which we have passed, Mr. Rao, if you can tell.
Page 62.
62.
In this matter,
Disposed of. Certified copy today.
representation lawsuit, yesterday lawsuit, I filed the application lawsuit, page number 50 lawsuit, page number 50.
Yesterday,
lawsuit.
it has not even reached university, right? Mr. Rao is not aware.
1/9 lawsuit.
1/9.
Yesterday,
Yesterday, 31st of August 23.
Yes.
Disposed of.
disposition charge, time frame lawsuit. CC today lawsuit.
Goes without saying, we are sitting overtime and doing this. What do you think? Delivering you copy on Tuesday? Not Tuesday. We will do it today. Certified
category
copy. Yes.
B category, my lord, under management quota, your lordship.
Management quota, Mr. Rao.
Because, my lord, because of he has not.
Which page?
Order copy also, your lordship, my lord.
Which
number
page?
20. Page number 20 is the same order, my lord.
22.
Similar order, my lord.
Huh?
No, that is different.
Different.
But he had a
different.
The order is way too.
Next, earlier case, my lord.
Earlier case. That page, which page? 62, same order in item number 4 also disposed of. No, everything you write, no opinion on merits, right? Yes. Yes, fresh petition.
Right. That's the local category. Claiming under local category, your lordship, as item 1 and 2 say.
So, what, how many lunch? More? No, 5 we have heard, no? 3 more. 3 more. You are the counsel in all the remaining matters.
No. Only one matter.
What is it?
Yesterday matter, my lord, yesterday.
He withdrew and filed a FED petition.
Yes, my lord, it's a local candidate of, my lord, the study.
Uttar Pradesh University, Uttar Pradesh State.
Local candidate, he wants now local candidate of
In
state of
Telangana.
Telangana.
This. What do you say, Mr.?
Studied 4 years there, Your Lordship. She studied 4 years by virtue of her mother's employment, shifted to AP, Your Lordship. But from born and brought up till 8, she was here only. 9th, 10th, and 11th, 12th, she studied.
Shall we say that Tehsildar will conduct an inquiry and all that order? Not opinion on merits of the claim, conduct an inquiry, issue 5 days, and then decide. Mr. Rao.
As per the presidential order, my lord, he is a non-local candidate.
You
We cannot
you
go-
seek instructions.
We cannot go beyond the presidential order.
No. So you seek instructions, then we will list it on Monday.
Yes, sir.
Heard on the question of admission, Mr. Rao, learned standing counsel for R2 accepts notice and prays for short adjournment to enable him to seek instructions. List on 5th of September 23. Because now it can be only third round.
Yes.
So second is already over. Yes. Yes, Mr. Kaushik.
Lordship, sir.
What is it?
In fact, Your Lordship, sir, previously when the matters were taken up, I've sought for a specific interim.
100%. This is coming up on 6th September, correct?
Yes, Your Lordship.
Then list on what the interim order, which is the order which is passed.
The interim order, Your Lordship, I have sought for-
Counseling is already over, my lord.
Ah,
Counseling is already over.
you have, so 6th of September.
any early date, Your Lordship, so that at least.
So all other cases are listed for 6th September. Third round of counseling can't be held. And in any case, if you succeed, we will decide what is the relief you are entitled to.
Obliged.
Prepare a synopsis like the one NCC candidate argued, right?
I shall, Your.
The counsel, how he formulated submissions and gave case law. That's the way.
Certainly, Your Lordship.
Don't like I was born in 1974 at a small village in the
Certainly.
state of Andhra Pradesh.
Certainly.
Learned heard on the, no, but this is a fresh matter, right? Learned counsel for the PT. You have appeared, Mr. Learned, you have appeared in other similar matters.
Yes, Your Lordship.
Or it's a fresh matter or old petition?
It's a fresh.
One is a fresh matter, and the other two, Your Lordships, have filed IAs.
Right now is 2-4. Don't confuse, Mr. This is 2-4.
3479 is a fresh matter, Your Lordship.
Learned, what's your name?
Anup Kaushik Karwati.
Learned counsel for the petitioner submits that he has filed a similar writ petition, namely WP number
18047.
18047/2023, which is
6 September.
which is fixed for hearing on 6th of September 2023. Full stop. Learned counsel for the university on instruction submits that the second round of counseling is over and the dates for third round of counseling are yet to be announced in view of a process submission. List for analogous hearing along with other connected matters on 6th of September 23, right? We will hear you on 6th September. And what this item 2, you have got it listed again, right?
I have
Fresh
filed,
IA.
I have filed IAs.
And got
Because
it.
Your Lordships have, on the last occasion when I have made a mention, Your Lordships have instructed that I might as well come with an IA. So I have sought for an expeditious hearing and a stay on the second round of counseling.
Fix a date of hearing, it is already fixed, like date of hearing. Heard on IA number 5 of 2023. After hearing learned counsel for the parties and taking into account the fact that the second round of counseling is already over and similar writ petitions are already fixed for hearing on 6/9/2023, IA 5 of 23 is allowed. Let this petition be listed for on, we don't say hearing, it will listed on 6/9/23 along with WP number, along with other connected petitions, right?
Both the matters.
Both the matters, same order.
Obliged.
So, Mr. Start preparing that synopsis, list of dates and your submissions. and separate compilation of case law. On that compilation, if you are relying on a Supreme Court judgment, it should be indexed which paragraph number. If you are relying on para 423, write that also. That helps the court, right?
Pleasure.
Yeah.
Number 95. Move it.
Jim. This is the letter. So last time there was one time to file objections. Yes, Mr. Not saying anything. Yes, you should. You want to file objections?
Objection.
You appear for whom? Learned counsel for defendant number 29 and 30. Again, and 39.
Dependent number 39.
And LRs of and learned counsel for LRs of defendant number 39 pray for and are granted 6 weeks further time to enable them to file objections to the report dated 6/3/2023 submitted by the receiver cum commissioner. I have file wakalat also. The learned counsel beginning you write undertake to file wakalat within a week. Thereupon office to print their names as counsels and then they pray for.
My be permitted to make mention. My LR petition was allowed on 19/12/2020. But so far, they haven't complied by bringing me on record in LR. Application number 1 of 2022. This was.
Who will comply? Who has to comply?
Registry, my lord. Orders have been passed.
All right. Registry shall carry out the amendment in the cost title in the light of order dated
19/12/2022.
19/12/2022. In the first you write this amendment, then undertake to file wakalat and then this order. Yes. Office note. Yes.
May it please your lordship. I beg to represent to Ms. Sanita.
Yes. Yes, Mr. You have to file. You have to file an application seeking substitution of LRs of disease response number 1. Condonation of delay. We had granted you time, you didn't do it. It was also, have you filed?
Before your lordships are pleased to peruse the.
No. Ask him whether he has filed 4/8/23.
May I have your lordship's leave to make a submission?
Yes, of course. By all means.
The respondent died in 2015 below.
The
respondent died in 2015. Why I speak. According to the memo served on us.
2023.
According to, may I proceed with the submission below? According to the memo served on us, they executed a will in 2014, registered will.
It's already stated.
Bequeathing the property in favor of 3 people, A scheduled to 1, B scheduled to 2 and 3.
But he's not making a decision. Tell him. Sir,
On 4/8/2023, there was an order directing you to submit a application for substitution of legal representative for deceased respondent number 1, along with necessary applications, along with condonation. Have you filed it?
I beg your lordship's indulgence to permit me to submit one thing, my lord. Under this will, the beneficiary also executed a will and she died before she is brought on record as legal representative.
Sir, already this court has granted stay on 23/3/2023. Are you aware of that?
Yes, my lord, that is stated by the arrest by Chief Justice and the present landed judge. I am aware of it.
Yes, thereafter a comprehensive report has to be filed for enabling you to pass this court to pass final orders. Meanwhile, if you want to substitute the respondent, you have to file an application to that extent.
He
doesn't want. You don't want to file.
The Hadil I am facing below the
What's the problem?
Hadil I am facing below the before the property vested in the beneficiary. The beneficiary died and executed in it.
Not understanding what we please appear in person. May I request you to please appear in person before this court to make your submissions.
Appear in person, he is asking. Appear in person in the court. Appear in the person in the court, he is asking. Yes, your lordship, give some time, so you can appear in the court.
Madam, don't you explain, you appeared on the last date of hearing. You are not explaining to arguing counsel what we have about the order which we have passed and what he is required to do. If he doesn't want to make an application, we will proceed. If he wants to make an application, then he should pay for time. He is doing neither. What should we do? Tell us. You understand, right? You appeared before the court on the last date of hearing. We granted you time. If you don't want to file an application for substitution, fine. We have said that we pass orders. You are neither paying for time, nor you are saying that we will not make an application for substitution. What should we do?
Millard, may I submit, Millard, in this matter? Millard, in this matter, there are two will deed. Before the respondent is brought in the record, Millard, he has died. So, Millard, the will is in the question now, Millard. So, if you want to submit for that reason, Millard.
Madam, if you are questioning the will, this is not the forum.
Millard will appear in person, Millard, will explain before your lordship. Your lordship may grant.
What's his name?
KB Satyanarayana is appearing.
Learned counsel appears through video conferencing and prays for adjournment to enable him to address this court in person. List after 1 week.
Oblige. Not one week, Millard, 2 weeks. He is out of station.
2 weeks. 2 weeks. 3 weeks. Why 2 weeks?
2
weeks.
I am deeply beholden. I am deeply beholden to your lordship.
The stay granted by Supreme Court, my lords, against order passed by my lords. The stay by Supreme Court, my lords, matters are pending before Supreme Court.
Which petition?
Last time it's.
So against the order dated 4/5/23, you had filed SLP.
Yes, my lord, spent. Yes, my lord. Next date is 18 September. It's coming up.
SLP.
SLP 1232023. But last time passed. 123202023.
23.
Yes, my lords.
Yes. 4/8 we have granted time. Hey, madam, where is the order sheet? Not here. Yes. 4/8. That is only for the limited period. So what happened on 18/8?
It's adjourned to 18/9, my lords, 18 September.
Again, yes, it is with the list after disposal of SLP. Learned counsel for the petitioners once again submits that the proceeding in SLP SLP number 12320/23 is fixed for hearing on 18/9/2023 before Honorable Supreme Court. Paragraph in view of aforesaid submission. Hearing of this petition is deferred. Signed I, learned. However, counsel for the parties are granted the liberty to produce the order passed, which may be passed by Honorable the Supreme Court in the aforesaid SLP.
Actually, there is a respondent represented, but the lordship said petition but respondent represented. They moved the Supreme Court, they obtained that order.
You are appearing.
I am appearing with petitioner, he is appearing for the respondent.
He gives an impression as if he is appearing for petitioner.
No, my lord.
You didn't say-
challenge the order of the. He
tell us.
He challenged the order. He challenged the order of this court, my lord.
But you didn't say that I am appearing for respondent. We got the impression that you are for the petitioner, respondent, madam. Learned counsel for respondent subjects. Yes.
I am appealing for the respondents, my lords. I request your lordship to grant 3 more weeks for filing counter affidavit, my lords. Item number 98, my lords. Requesting 3 more weeks, my lords.
Mr. Santosh Kumar. Yes, Santosh Kumar, learned government leader, once again prays for adjournment to enable him to file counter list after he is permitted to do so list after 6 weeks.
This matter, I am appearing for the petition below. I am repeating Muhammad Adnan below. I may be permitted to withdraw the petition to avail the alternative remedies below.
Learned counsel for the petitioner seeks leave of this court to withdraw the writ petition with the liberty to pursue the remedy which may be available to him in law with regard to his grievance. In view of aforesaid submission, the petition is dismissed as withdrawn with liberty as aforesaid.
I am appealing for the respondent 1 to 6 months. Appealing for the respondent.
Even for respondent 7 and 8 months.
Requesting 4 weeks time for filing counter.
Madam.
Matters.
You have filed counter.
In item number. Also file counter.
Learned senior counsel, learned Mr. Swan. Yes.
I am appearing for the petitioner.
Fine.
But under the guise of this implement proceedings, they want to in a survey proceeding, they wanted to deliver the possession which is contrary to the law laid down by division bench of this honorable court. And also, when their civil suit is dismissed, and also, when their application for delivery of possession is they have withdrawn before this honorable court. But there is so much of record, which I take your lordship, kindly see page 24, which is the order impugned herein.
What is
see the
no, Mr. Counsel, government advocate and learned senior counsel for 7 and 8, they are paying for time to file counter. You want pending that you want some interim order to be passed, right?
But they are your lordship, they are demolishing the structures which photographs I have
Kindly
see.
They
have seeking stay of survey. Actually, survey has been conducted, as I understand, in the month of May itself. The survey proceedings are to be published. If they have objections later for the survey
demarcation and delivery of possession, they are saying.
My lordship may kindly see that survey has already been conducted. Now the survey proceedings are being published by the government, as I understand.
When it has.
I think in the month of July, it has been concluded, madam.
I need to get instructions from the minutes.
Your lordship, kindly see
Petitioner challenging the proceedings dated 24th. Petitioner challenging the proceedings dated 24/5/2023 minutes. Now
1 minute, Mr. We will hear you, don't worry. But let us understand what is it. You are referring to documents without telling us what is the interim relief you are seeking. So we are trying to understand from respondents what do you want. Then you will read 478 and 440. Yes.
In this case, petitioners challenging the action of
the senior counsel, he is survey demarcation delivery of possession of survey number 57. Have you filed counter?
Will file counter.
No, but what happens to survey when it has been done?
Your lordship may kindly say, as I understand, the survey notice which was issued in May 23,
Thereafter, in July 23, the survey has been conducted and the government, the concerned officials are in the process of issuing the survey proceedings. It is only thereafter everything will happen. If there are any objections, as I understand, well, not in fact, originally after issuance of notice, as I understand, certain parties had submitted their objections, which were already dealt with by the concerned government officials. Thereafter, survey was conducted. The survey findings are awaited from the government. So let the government appraise the suburb.
Council, this, in fact, this is a part of CS7, right?
Yes.
Okay, if that is the case, a new, the receiver has already filed a report. Please obtain a copy of this, and if you are objecting, file your objections. After accepting the report, we will hear this writ petition.
So far as Millard, this is concerned, report has nothing to do with, because Millard, in fact, the receivers themselves have filed a counter opposing Millard delivery of position, saying that we have not signed this,
Sir, please understand, this report was filed of late. It's a new report. Are you aware of that?
But that new report, Millard, they are denying everybody's right. But that is a different matter.
File your objections to that. It is nothing but parallel proceedings. It amounts to parallel proceedings. You don't want to file objections to that. This writ petition can be heard. Tell me.
My small submission, Millard, for this case is, Millard, it is the unofficial respondent, official respondent are trying to, you Lakshmi kindly see page 437 there, under the guise of survey, they are interfering with my possession and they are trying to demolish the structures. I filed, Millard, the bulldozers as late as 18th August 2020.
Sir, when the final decree proceedings have not been passed till date.
It is passed, Millard.
Where?
There is a.
You better appear in physical mode and argue. We are unable to accept your submissions.
That's correct.
Need to file counter matters anyway.
It has to application to the MO and no other can enter the division bench confirmed that confirming the circular.
Brother, you said that you appear in person, right?
The guys of survey, but they can't start to deliver the possession of the property. Kindly see division bench of the honorable court at page 364, page 364. This is a petition, where not single judge of this honorable court, disposer of the writ petition, saying that the prayer is also extracted for a delivery of position, and since there is already earlier direction, no further direction can be granted. But division bench of this honorable court noted the prayer and said, in fact, this writ petition should have been dismissed on that ground. A delivery of possession cannot be. It is a matter pertaining to the civil courts, where they have to go to civil court. But they have sought for delivery of possession before the Tahsildar. That you would find in the impugned order at page 25, Millard. They sought for delivery of possession from the surveyor, which they have failed before this honorable court. They filed an application for delivery. Receiver objected to, saying that the plan appended is bogus. Then they withdrew the application which they filed before this honorable court in CS7. They withdrew it. And then they goes to the survey people. They readily entertain. The collector entertains. This honorable court said it is only the Mandal surveyor who is the primary authority, before whom only an application for survey can be made and entertained. Here, collector writes straight away to RDD. which is found fault, my lord, by this honorable court, a division bench of the learned single judge, referring to all circulars. But that judgment, my lord, your lordship would find, my lord, at page 399, my lord, relevant portion, where entertaining of applications straight away by the higher ups, contrary to the circulars, is found fault. Even in there also, my lord, RDD who entertained the application.
What is simple survey?
And the first division bench, my lord, at page 368, my lord, relevant portion. Division bench of this honorable courts and that it is the realm of civil court.
Lordship may kindly permit us to file counter. Lordship, in fact, in this case, government had filed.
Mr. Mr. Counsel.
RDD in
Mr. Counsel for petitioner, can you
Learned single judge which was approved, learned single judge order is at page, relevant portions are at page 392.
The moment will.
Hello, counsel. There is a technical issue. We are not able to hear your submissions. Please appear before this court in person and make your submissions. We'll take up next week.
Okay. On account of technical issues, this court is unable to hear the submissions made by learned counsel for the petitioner list next week.
That's want to file Miller objections for the commissioner's report in both the cases, appeal for the petitioners. Not to grant me 2 weeks for filing objections, Miller.
Last time we had granted.
I could not make it.
Learned counsel for the petitioner praise for and is granted. The applicants praise for and is granted 6 weeks further time to enable him to file objections to the report submitted by receiver cum commissioner.
Apply.
Same. 6 weeks. 103. 103 to 105 also same. Call madam. 103. $102 same order, madam. 6 weeks time. What happens to 103? 103, 6 weeks time. 6 weeks too. Same order, madam. 104. No representation, let objections, if any, to the commissioner's report be filed within 6 weeks. 105. Call, you have to. No representation, let objection, if any, to the commissioner's report within 6 weeks. 106.
Miller, in this matter, Miller, I'm appearing in this matter, Miller. Miller, I want 6 weeks time, Miller. I'm
Same
very
order.
sure.
Praise for adjournment.
Bless.
Praise for and is granted 6 weeks time to enable her to produce the succession certificate list after 6 weeks.
May I request a lot, kindly grant me 2 weeks time to file objections to the report.
4 weeks.
4 weeks.
Praise for and is granted 4 weeks time. Learned counsel for the applicants petitioners. Praise for and is granted 4 weeks time to enable him to file objections to the commissioner's report.
All right. Good.
In this case also, respondent has to file objections to the report submitted by the commissioner minutes. Time for the appellant.
Learned counsel for respondent praise for and is granted 6 weeks time to enable him to file objections to the report submitted by the commissioner. Yes.
The petitioner wants to file successor in 4 weeks time.
What wants to file?
Successful certificate.
Learned counsel for the petitioner, praise fund is granted 4 weeks time to enable him to produce the succession certificate. 110. Yes, Mr.
Doctor, grant me 2 weeks, my lords, for completing of his objections. I applied for certified copies, my lord, for furnishing the amended copy of the cost title. That I'm awaiting that. I filed a memo to that effect.
4 weeks time to file amended cost title. Learned counsel for the petitioner, praise foreign is applicant, whatever. Praise foreign is granted 4 weeks time to enable him to file amended cost title.
Both cases. Next item.
111 also. Yes. 111 also. Same order. Yes.
May I please your lordship, I'm appearing for respondent number 8, my lordship.
Yes.
And, your lordship, I have.
Somebody, you are not visible, Mr. Counsel.
Your lordship, there is some technical issue. Your lordship.
All right. So what you want time, right?
Yes, my lordship. Like I have been roped in this writ petition, my lordship, as if I have filed.
No, Mister, you should be visible to us, right? Why don't you appear in person?
Much obliged, lordship.
Kindly
grant us some time, my lordship. Next week.
Learned counsel for the petitioner, respondent.
Respondent number 8, my lordship.
Learned counsel for respondent is for adjournment. List in the next week.
Much obliged.
Learned counsel for the petitioner prays for adjournment on the ground that the matter is to be argued by senior counsel. List after 4 weeks. What is applications? None for the applicant. None for the applicant. In this application, the prayer has been sought for. No, none for the applicant. We have perused the record in this application, the petitioner has has prayed for passing of final decree in favor of the petitioner in respect of the land measuring 10.12 guntas in survey number 1/1 of Hashmatpet village, which is part of item number 2 of schedule Roman 4A of preliminary decree dated 8/6/1963, passed in CS number 14 of 1950, paragraph 58, sorry, 58. A new receiver has been appointed by this court who has submitted who is yet to submit a report. Therefore, at this stage, in the absence of report submitted by the commissioner, prayer for passing a final decree cannot be entertained. Line below the application, it is disposed of with the liberty to the applicant's petitioners to approach this court at an appropriate time. After the after submission, not appropriate time, delete. After submission of the report of the commissioner, accordingly, application with the aforesaid liberty, application is disposed of. Now we have said none present. None you have said.
Lord, this application, Lord,
150.
under order 21 rule 97, Lord, objections were raised by the Lord office. Lord, I will complain, Lord, 4 weeks time may be granted, Lord.
Mark is present.
I will
Learned
permitted
counsel
to.
for petitioner prays for it and is granted 4 weeks time to enable him to comply with office objections.
Lord, I am permitted to go through the Lord objections raised by this.
Of course. Yes.
Next one also similar, Lord, 116 also.
116 same matter. Yes. 117.
117 to 125 also there are certain objections, I suppose.
117 to 125.
117 to 125.
That's what we are seeing.
But there are certain objections. Your Lordship may grant me some time and
4 weeks. Learned counsel, Mark is present, learned counsel 170 to 125. Learned counsel for the petitioner prays for and is granted 4 weeks time to enable him to comply with office objections. Yes.
Next. With the.
Let us. Then we have to open. Because we were the wanted to became reporting shown. So we continued in 14. And then thereafter we saw this. 14 close. In his place we have to procedure. In fact, I requested the next week. In says we continue in the 7 we don't have to be in right. List next week.
CS 14 minutes were pleased to appoint Mohammad Nizamuddin as a receiver and commissioner minutes. Report is awaited minutes. Minutes may kindly take up this matter after submission of report minutes.
Report. Report.
Yes.
There are already reports.
Await the report of the commissioner. Let the matter be listed after the report submitted by the report is submitted by the commissioner stroke receiver. Interim order shall continue.
It is for the receiver to submit report minutes.
Doesn't represent, he doesn't make a difference.
Receivers, they are not coming. Receivers, they are not coming to the standards.
We'll take it up next week.
Yes. Now, the result receivers are-
Delete. Delete.
Receivers are, I never saw anybody represent receiver. And no report is coming forward. I have-
No, Mr. For some reason, we are saying that we will list it next week. Next week, you are protected by an interim order. It will continue for 6 days or more days. We will take up. Later on, when you, why do? Later on, you file when it is to be taken. Or you file in the office if you want to. Why to give it here? Yes.
This matter also minutes. This matter also minutes. Identical to item 127 minutes. This matter also minutes. Report of the commissioner is awaited minutes.
Mr. Report is awaited 128.
He is not representing in 128 minutes.
Not appearing, then why are you standing there? None for the petitioner.
127 it is
None for the petitioner. let the report be submitted by the commissioner. List after 4 weeks. 129.
Because in this item 129 and 130 also, there is a direction for awaiting the report of the advocate commissioner.
Let the awaiting, no, delete awaiting submission of report by the commissioner. Hearing is deferred. List after 4 weeks. 129, 130. Let's look. Nobody is appearing for it. This.
Rashmi, kindly short pause of my side.
Huh?
Advocate General is appearing in these matters, my lords. Rashmi, I will inform my lords. I'm not aware, my lords.
No, before a special bench, right? Can you?
Yes, my lords, I'm aware, my lords. I thought so.
These are first appeals, 4 first appeals arising out of common judgment in respect of 2 suits. It takes a lot of time because there is a voluminous record. The entire previous history is required to be placed before your lordships. That is the problem.
We only can request the young colleague assisting you to prepare a synopsis to cut short the time instead of those. Got it, Mister? What's your name, young count man?
I have
What's your
filed.
name? We are asking him something.
Akash Upadhyay.
Mr. Akash Upadhyay, prepare a date-wise what happened when. Prepare and give seat to senior. So that we can cut short the time. We don't have the luxury of hearing it for months together, right?
In fact, I have filed all the details earlier. They are on record. I have filed so many things there.
No, we are also ready to hear, but.
Sorry, Millet. Let's
He said Advocate General, you are not Advocate General.
Millet, I'm attached to the office of Advocate.
He said Advocate General will argue. Yes.
I'll prepare
This is appeal under 96.
Yes. Millet, one short point that was to be educated on the last occasion, I made a representation of your lordship is the preliminary decree.
Under 96.
May accommodate me by week, my lord. I'll be ready with the chronological dates, my lord, and I'll place it. I will not take more than 5-10 minutes in this case, my lord. My country.
He says that huge. That he said that it will take.
Mayor
council.
My lord, it may be their case, my lord. As for the case of the government is, my lord.
You are the appellant, right?
We are the appellants, my
lord. Two appeals at least we can decide.
Yes, my lord. Yes, my lord. 10 minutes, my lord. My lord's time, 10 minutes, I can satisfy your lordship. This
Mr. Upadhyay, tell your senior that they are saying that they will conclude in 10 minutes.
10 minutes, yes.
No, they are saying that we will conclude. You are saying days together. It's their appeal, right? What date?
Any date, my lord. Next week or that next week, my lord. I'm ready, my lord. 15th, dates, my lord. Any date, my lord. I'm sorry. Any other date, my lord. Other than 8th, my lord, any other date, that's a senior's request.
What is the voluminous record? It's there. This
15th September. 15th September.
15th September.
15th September.
I have inconvenience up to 20th. In that event, lordship, you have up to 20th. 22nd, your lordship may have it.
22nd September.
Yes, obliged.
31 to 154. He prays for adjournment to learned whatever. You are
government leader, my lord.
either attached to
AGO.
prays for adjournment to enable him to prepare a synopsis and produce the same.
everything is
I'll
fine.
prepare a synopsis along with written submissions.
Yes, sir.
And to produce the same list
Thank
on 22nd September 23. You also, Mr. Upadhyay, filed written submissions.
I request Lordship to direct the office to verify entire record which is produced by both the parties. We have filed several books here because I don't think.
Then we don't have any reason to disbelieve that it's not in existence. Supposing you file that that it is missing and all that, how do we know? We don't know what is at this point of time. We don't know against which judgment and degree the appeal has been filed.
After serving them only, I have filed all those records.
No, but can you say that it is missing? It is a case then for an inquiry to be conducted.
I am not saying that. Let them place the entire record so that there is a lot of record is there. All right, let it be there.
Record not there.
I have prepared the compilation.
They will make it available, mister. You please ask the young man to focus on written submissions, which will be prepared under your directions, right? That's a better way. She will take care of the record and produce it.
Submission. Oh, will permit me to give some books, Lord, on all legal issues. I'll give the list, Lord, will permit me, I'll come and give the list. I want to give non-legal books from library.
In this case, whenever it is called 22nd September, you can give the list.
Not for this case. General, I want to give some books.
Library.
General books. I want to give
some library books. You can donate the books. We will tell Registrar General. You donate such a beautiful library by the Bar Association has been, but why are you mentioning? You should go talk to President of the Bar Association.
Your Lordship, humble
We'll
submission.
take it up today itself.
No,
Today,
my lords. Next week, my lords.
Next
I'm
All right,
taking a
next-
listing of the matter.
all right, next week. No, we thought it's urgent. So next week, right?
Your Lordship, humble submission. Arbitration application 32 of 23, Your Lordship. It's not arbitration application 32 of 23. It's not been listing, Your Lordship, for since last 3 months, Your Lordship. So kindly requesting,
What is the stage?
Your Lordship.
What is the stage of the application?
Stage is to serve the notice to the respondent, Your Lordship. We have
Have been served
Yes, Your Lordship. We have served and
next week.
With your Lordship's kind permission, my lords, requesting listing of 5 connected arbitration applications, my lords, filed under the section 11, my lords. The stage is at, the notices have been served, my lords, on this. Much,
So they will seek time to file counter, right? 4 weeks.
my lords, they've not come on record as well.
Next week.
Much of that.
May I make mention, my lord, subject to lordship kind permission?
Yes, please.
My lord, arbitration application, my lord, number 229 of 2022. My lord, the other side also appeared, my lord, and they took time, my lord, for filing counter. Since then, my lord, it is not getting listed since April. Lordship kindly next week, my lord. Right.
Next week. Next
Oblige.
week.
229 of 22. Oblige.
No, but you should give a memo, right? It's not online doesn't mean that you will not even give a memo for listing. Please give a memo. Ask your colleague or junior, somebody, your friend here to give a memo.
Okay.
List it, mister. We will list it, but
Very
you
good.
give a memo, right?
I'll get it done.
Yes.
Oblige.
Yes.
Were purchased from the builder, my lordship. Invitation clause in 25, my lordship.
Notice. Learned counsel for the petitioner. Learned counsel for the petitioner submits that the agreement for sale dated. Agreement for sale dated. Agreement for sale for semi-finished flat dated
December 2001.
1/12/2010 in respect of flat bearing number S2 in second floor of Ravi Kunj measuring 1741 square feet contains an clause 15 of agreement, right? In the beginning you write clause 15 of agreement for sale of unfinished whatever semi-finished flat contains an arbitration clause in view of aforesaid submission. Notice.
Last one permitted personal notice, my lord.
This all personal notice and proof of service. That's it.
Next matter regarding the S3, my lordship, in the same.
Madam, same order.
Yeah, regarding the S3, my lordship.
Yes. Flat number S3.
S3, my lord.
Madam, flat number S3. Same order. Notice.
Regarding this also personal.
Personal. None for the petitioner hearing is deferred list next week.
Lordship arbitration application filed under section 11, Your Lordship, for appointment of arbitrator. Applicant and the respondent entered into a plea agreement on
Which clause?
9.2, Your Lordship, page number 24, Your Lordship.
Learned counsel for the petitioner submits that the film agreement dated 20th February 2022 20th February 2020 submitted that clause 9.2. Clause 9.2 of the film agreement dated 20th February 2020 executed between the parties contains an arbitration clause. In view of aforesaid submission, issue notice. Personal notice. Yes.
My lordship, page 26 is the development agreement cum irrevocable GPA entered between the applicant and the respondent, my lords.
Learned counsel for the petitioner.
Page 32 clause 18 is the arbitration clause, my lords.
Learned counsel for the petitioner submits that clause 18 of the development agreement dated 25th October 2018 executed between the parties contains an arbitration clause. In view of
My lords, there is a interlocutory application under section 9 also has been filed, my lords.
In view of aforesaid submission, issue notice, personal notice, proof of service. What?
My lords, there is an interlocutory application IA 1 of 2020.
No, you can file it in a arbitration petition or separately.
My lords, actually under section 9, if we file standalone section 9, it has to be filed in principle.
Standalone means
only for section 9, we will file it in the principle.
What are the rules? Every High Court has made rules under 11.6. What are the rules for the state of Telangana? Who is this person? Is your advocate? Standing behind.
Client.
Then ask him to sit down. He has engaged you, right?
Yes, sir.
Then he need not stand. Supposing if you go to a hospital, whether your relatives or this thing stand in the operation theatre, no. Doctors take care. So tell him that you are taking care of his case. So what are the rules, Mr. Under 11.6 rules? Telangana High Court must have framed rules or adopted rules. I have come across for the first time that 11 petition section 9 is filed. Address on the question of maintainability. Ready? Not ready. Brought rules? No.
But the act does not preclude the High Court from granting the relief under the section 9 also.
No. It does not preclude. This all settled, mister. Nobody has argued like this without arguing, bringing books, etc. You are relying upon us, right? We will not do it. Carry out research. When a question was put to learned counsel for the petitioner, right there, about the maintainability of a petition under section 9 of the Act in a proceeding under section 11 within bracket 6 of the Act, learned counsel for the petitioner raised for adjournment to enable him to examine the aforesaid aspect. List. Next week. Then why issue notice? Then there's no point in wasting.
My lord, because it will further delay the proceedings, or let me withdraw A1 and approach the appropriate civil court, my lords.
Now you have got the answer, right? Just like taking chances, we see whether court grants.
No, my lords,
Mister, we are keen observer, right? So people here appear through video conferencing. Then all of a sudden, the moment we start asking inconvenient question, the technical problem will arise. So like that only.
No.
So yes, issued that personal notice, etc. Then say learned counsel for the petitioner seeks leave of this court to withdraw IA 1 of 2023 with the liberty to file the same before the competent court. Accordingly, the aforesaid IA is dismissed as withdrawn with liberty as aforesaid. Yes.
May I please?
Which clause?
Clause 10, my lord. Clause 10.
Learned counsel for the petitioner submit that clause 10 of the agreement executed between the parties dated 18/4/2019 contains an arbitration clause. Aforesaid submission, issue notice. In view of aforesaid submission, issue notice, personal notice, proof of service.
Obliged.
My lord, this is the application for appointment of arbitrator. Clause number 13 of the MOU dated 14/6/2006, my lord.
14/6/2003 or 6?
2006, my lord.
You have wrongly written here 2003. Learned counsel for the petitioner submits that clause 13 of MOU dated 14/6/2006 contains an arbitration clause. Aforesaid submission notice.
Obliged.
Yes, madam. I have responded.
It's an application under section 11, your lordships. It's invoked under franchisee agreement, your lordships. Clause is under
Which clause, madam? What page?
Yes, your lordships.
I'm for the respondent. I'm opposing the application, my lord.
Why?
The reason is the
Yeah, first.
You are ready, right? You are
Yes.
not seeking adjournment.
No, your lordship.
Fine. Which clause, madam?
Clause 17.1, your lordships.
Page.
At page 34. Governing law and dispute resolution. If I may read your lordship.
Agreement dated
Agreement dated 11/11/2011.
Yes.
If I may read 17 clause, your lordship. Second point, your lordship, second paragraph. Any dispute, controversy or claim arising out of or relating to this agreement or the breach, termination or invalidity hereof shall be settled by an arbitration in accordance with the Arbitration and Conciliation Act as in force that date before the arbitrators mutually agreed by both franchisor and franchisee and appointed by the franchisor and franchisee mutually. The decision of the arbitrator shall be final and binding on both the parties to the agreement. The arbitration shall be held at Hyderabad in English. Further, if one party to the agreement disagrees on the award passed by the arbitrator, then the party shall file before the court of law within 15 days of such arbitration ruling. That's the arbitration clause, your lordships. I have filed for a claim of rupees 30 lakhs, your lordships. There are 3 disputes raised by the other side in their counter, your
When did the claim, dispute arose?
dispute arose as per the legal, as per the show cause notice issued on 10th.
Happened after agreement was executed in 11, then how dispute arose? When? Probably that's what he wants to argue.
Yes, your lordship. That's the entire point of argument here. The show cause notice was issued on 10/5/2017.
The show cause notice means what?
Show cause notice to terminate the agreement.
You are an authority, right?
Yes, your lordship.
That's why you are issuing show cause notice. Otherwise, we were wondering individual, how can he?
We are a company, your lordship. We run schools and give it for franchisees.
Yes, then.
Yes, your lordship.
Issue the show cause notice to terminate the agreement.
Terminate
Then
the
what
agreement.
happened?
Then, your lordships, we filed a first arbitration application in the year 2021. That was with arbitration application number 158 of 2021.
This is 11/6, right? When you say arbitration application means 11/6.
Yes, 11/6, your lordship, for appointment of arbitrator. However, we withdrew the said application, your lordships. The order copy is filed at page 49 of the petition. The reason for withdrawing the said application is, your lordships, page 49.
You have to seek review of that order, madam. You can't unconditionally withdraw and then furnish subsequently. That is why this order binds you.
Yes,
If it doesn't grant, 1 minute. If it doesn't grant you the liberty to file afresh, then it is gone.
The liberty is given, your lordships, if I may read. First paragraph, third line, your lordships. The Learned Counsel.
Page.
Page 49.
Yes. Yes.
The Learned Counsel, third line, your lordships. The Learned Counsel further submits that statutory notice was not issued to the correct address of the respondent, and the steps are being taken to rectify the said defect. In view of the above, the arbitration application is dismissed and withdrawn. However, if new application is filed, the same shall be decided on its own merits. Now, this is the arbitration application we filed in 2021, your lordships, within 3 years from the date of issue of the show cause notice. Period excluded.
No, when you filed?
In 2021, your lordships. Exact date.
No, this order is dated 29/7/2022, madam.
We filed the application on 1/10/2021. 158 of 2021 application we filed on 1/10/2021.
No, that is correct, madam. This you have withdrawn on 29/7/2022.
Yes, your lordships.
When this petition, when it has been filed?
This petition was filed
Subsequent to July, right?
yes, your lordship, subsequent to July.
You are referring
yes.
a date in 21, that's what is confusing. 21st October 22. Yes.
So we filed an arbitration this application after issuing of the legal notice again to appointment, that is on 1/8/2022. which is filed here.
What are the grounds on which your prayer is being opposed? Tell us.
Yes, Your Lordships. The first important point is the limitation point.
Ah.
The argument raised here, Your Lordships, is that
Barred by limitation.
is barred by limitation because the show cause notice was issued in 2017. However, from 2017, the contention would stand if we would not have taken any action. We did not sleep over the rights. In fact, there's a case law filed by the Learned Council wherein it says that exclusively prima facie, if it's barred, hopelessly barred by debt, then the limitation would survive. However, in this,
What case law you are relying?
I'm relying on the same case law filed by Sir, in
Very
which
good.
it says if you do not take,
Mission is not like that.
read
Let her argue, yes. But we are giving her an opportunity, right? Don't leave it to us, madam. Don't leave the research work to the court. It will.
Yes, Your Lordships, I will read out everything issued. Yes,
No,
Your Lordship.
I mean, this case law position, don't think that we will find out the case law in your favor. You are saying that you are relying on the same case law. I will
I
decide.
will enlighten the court, Your Lordship, why I am relying on the same case law filed by Sir. If I may
23
take Your Lordship's
temperature.
attention.
23. Yes, so first is barred by limitation.
First is barred by limitation.
Second-
Second is with regard to the fact that we have not filed the original or the certified copy of the franchisee agreement. If Your Lordship's permits, we'll file the same. It is very well in our custody. The reason for not filing the same was because the arbitration clause is clearly visible in this agreement. If Your Lordship's permits, we'll file it on the next date of
Yes,
hearing
third,
itself.
what third?
Third one is with regard to the disputes of the amounts, royalty amount. However, that can be decided before the arbitral tribunal.
So what is the limitation?
Now, the limitation aspect, Your Lordships, if I may take Your Lordship's attention to the
You first must understand what is their objection to limitation.
The objection is because in 2017 we issued them the show cause notice terminating the agreement, and then they say in 2021 we filed the first arbitration application that was also withdrawn, and then we filed this application. So you cannot seek for limitation from 2017 till 2022 on the same notice. That's the major limitation dispute. It is well agreed, Your Lordships, that the notice was issued in 2017, post which, due to some technicalities, the suit was withdrawn. And then we filed this arbitration application. Now,
What is the position of law of counting limitation on a previous cause of action?
it is 3 years, Your Lordships. From 2017, 3 years we have to calculate.
Which provision?
Article 137 of the Limitation Act, Your Lordships. So, if I may take Your Lordships to...
No, correct. So 2017, 10/5/2017, 3 years you had filed. First application you filed when?
In 2021, Your Lordships, post-COVID period.
Within 3 years.
Yes, Your Lordships. On 10/5/2020, the limitation ends, but we've taken the time of COVID and then we filed it in 2021. So that is
Date.
Date of the first agreement, Your Lordship, first application.
Application.
First
Fine.
application 1/10/2021.
110. First application filed.
1/10/2021.
Which is that Supreme Court judgment which says that COVID period has to be excluded.
I have not filed it here, Your Lordships, but since I was explaining with regard to the Article 137.
No, who suffers if it is not like we told you, madam. You are appearing here to assist us. We will say that after COVID period filed, judgment not cited. He is not expected to cite judgment in
Yes,
your
Your
favor.
Lordship, that is.
He will say that it is barred by limitation. That's why, madam, before venturing upon argument half-hearted, don't do like this. It's not good. It gives a bad impression to the court that half-heartedly you are arguing without making any research. I told you in the beginning, whether you have made research, you said I am relying on same case law.
Pardon me, Your Lordship, I shall file the same COVID citation at the next hearing itself.
No, because then I will have to search.
No, I shall file it. I shall file it, Your Lordships. However, if I may continue.
Learned counsel for the petitioner prays for adjournment to enable her to prepare the case and argue the same list next week. Yes.
Grateful, Your Lordships. Please, Your Lordship, appearing for the applicant, Your Lordship, the counsel for the respondent has just served his counter, Your Lordship. I have just received the counter. Hence, Your Lordship may adjourn the matter by 2 weeks. I'll file my reply, Your Lordship.
Learned counsel for the petitioner press front is granted 2 weeks time to enable her to file reply to the counter.
Deeply obliged.
Please, my lords, I'm appearing for the applicant in the fact. Notice has been issued, respondents have been served, and as per my limited knowledge, respondent No.1 has filed the counter, my lords.
So far as R1 is concerned, I filed my counter, but the senior counsel is unveiled, that's the reason I'm requesting time. R1 I have filed counter.
You have filed counter.
For R4, my lord, submission. R4 is governor of Arunachal Pradesh, my lord. Governor cannot be made a party, my lord, as per Article 361. He is provided a complete immunity. The contractor entered under Article 299.
Mr. What is
State of Arunachal shall be made instead of governor of Arunachal Pradesh.
My lords, I have no objection. Respondent number 4 may be represented through the chief secretary. With permission, I'll seek leave to file amending memo of parties, my lords, if it is the hurdle before my lords.
In view of objection raised by learned counsel for the petitioner, learned counsel for respondent number 4, learned counsel for the petitioner undertakes to amend the cost title by correctly describing the respondent by deleting the name of the governor of the state of Arunachal Pradesh and instead to implead state of Arunachal Pradesh through chief secretary. Let this be today. You will do. Let this be done during the course of the day. Just now. Let this be done during the course of the day.
The notices issued out of no.
You are appearing, right? Government not appearing.
For governor of.
You don't appear for the state.
At this point,
we have to issue notice.
Please, my lords.
You do it just now, so that
we'll do it.
And the notices issued to governor of no sequence, no consequence.
Obviously, when the name itself is deleted, nothing. Right?
Let's let notice be issued. We'll take out the notice.
So notice to respond number 4 and personal notice, whatever proof of service. You just do it, Mr. Just now, correct.
Please, my lords, may I request to have it on 29th of September? It's a humble request, my lords. It's the next date of hearing. If I may request to have it on 29th of September, my lords, because I'm an outstation counsel. That is why I'm requesting.
Hey, you first correct it, Mr. What outstation counsel? You don't know. You need the governor of this thing into a litigation. What is this?
My apologies for that. Please.
You better focus on legal aspect rather than in station outstation.
I missed it personally. That is my
list on 29th September. You just now correct it, Mr. Before leaving. Don't say that outstation, therefore I am leaving.
Please, ma'am. No, I'm doing it.
No, do it just now.
Yes, ma'am. Yes, ma'am.
Give the file.
Please, my lord. This petition is filed seeking appointment of an arbitrator, my lord.
But the respondent number.
Agreement of sale.
Before my friend starts, once.
Yes.
I am for the respondent number 1. Now, application is filed seeking the appointment of the arbitrator. In fact, my lord,
you want to file?
File by counter.
Counter is filed. Counter is filed.
A dispute between the landlord and the developer is not referred to an arbitrator, and the adjudication stage is over. Now today award is to be passed. Once that award is passed, my lord, I will be settling this claim of the present petitioner. So your lordship may just adjourn it by 1 week. It will.
That has no bearing on my claim.
Right, so you can still argue, right? Next week he said, next week we will hear you. Not doing anything. Learned counsel for respondent, senior counsel for respondent, praise for short accommodation. List next Friday.
Yes.
What is the date?
Friday week.
8th September.
Obliged. I may not be there, man. Lordship may kindly accommodate me.
Then what date?
Friday week, man.
15th September. Next Friday is 15 September. 15 September 23.
Obliged.
Yes.
My lords, this is a section 11 application filed
Ah.
for, my lords. My learned,
Yes, you had proposed the name.
Justice Venkateshwar Reddy, my lords,
Ah.
Justice Santosh Reddy, I'm agreeable with the.
All right, fine. This petition under section 11 within bracket 6 of the Arbitration and Conciliation Act 1996 has been filed to seek an appointment of an arbitrator to adjudicate the claims and dispute between the parties. We have passed similar orders on the last date, no? You know, parties have agreed. This thing, when the matter is called today, learned counsel for parties jointly submit that Mr. Justice A. Venkateshwar Reddy, former judge of this court, be appointed as an arbitrator to adjudicate the dispute between the parties. Full stop. In view of aforesaid submission, Mr. Justice so and so is appointed as an arbitrator to adjudicate the dispute between the parties. The parties undertake to appear before the arbitrator on which date? Which date you tell us? 9 September.
9 September.
9 September 23 at 11 a.m. The arbitrator thereupon shall enter the reference and shall proceed. Accordingly, petition is allowed. Yes.
My lords, I am for the applicant for seeking time after 2 weeks. My lords, we have received a memo seeking time for 2 weeks. My lords, senior.
Same thing, respondent, you sought adjournment, right?
My lords, I sought time, my memo.
Now Article 14, he also must get an adjournment. Otherwise, Article 14 will be violated, no? No, this is all, Mr. Please appreciate, this all is a summary proceeding, right? You keep it pending like a civil suit, want it to be decided after 25 years.
My lords, my senior was there here till afternoon. My lords, due to some medical emergency, he has to leave immediately after lunch.
Next week? Next week?
Let's take it up on the 15th. My lords,
Praise for adjournment on the ground that the arguing counsel is not available on account of personal difficulty. List on 15 September 23.
My lords, 148 and 149 are also the same matters connected.
Yes, my lords, 147 to 149 are the
Same. One 47 to 140.
May I please? You know, the application is filed for appointing the sole arbitrator. To remove
Notice has not been issued.
I have filed my personal notice. Sir. But the
Respondent is served, madam.
Service is not filed, sir.
Proof of service not filed.
It's filed, Your Honor.
When? Show him the endorsement.
That's the card.
When did you file?
On the last occasion. That's the acknowledged card.
Acknowledgement is there, no madam. Then why are you saying?
Even in the list, it's mentioned as the.
I fine. Acha, nobody appears. Yes, mister. Come here. These people stand, you are not visible. Yes. So, which is the arbitration clause, Mr. Simple, right?
Yes, sir.
Nobody is appearing to oppose.
Yes, my lord. To invoke the clause 21F as per page 24 of the material papers.
Sole arbitrator.
May I please? Any dispute arising out of this agreement or any manner touching upon it, the same shall be settled up through arbitration.
What, like former judge of this court?
Pardon me.
What is the quantum of the claim?
Amount is 63 lakhs 50,000.
we can appoint a former district judge of,
Yes, my lord. In fact,
of the list approved. Madam, list of arbitrators, mark the presence, none has appeared despite service of notice. This petition under section 11 within bracket 6 of the Arbitration Conciliation Act has been filed seeking appointment of an arbitrator. Paragraph. Facts giving rise to filing of this petition briefly stated up that the parties had entered into an agreement, namely School Academic Solution Partnership Agreement parties had entered into an agreement on 26/12/2018. Huh? Yes, madam, 26/12/2018. Into an agreement, namely so and so, on so and so, namely so and so agreement. Full stop. Clause 21 within bracket F of the aforesaid agreement is reproduced below for the facility of reference. Paragraph. The dispute between the parties have arisen and therefore despite service of notice, the respondent has so company and school have to appoint. You are not company and
for the
school.
company.
Then you have to appoint.
We have sent the invocation notice, Your Honor. The
Line
appoint,
below. Despite notice being sent on
1/6/2023.
1/6/2023, the
Sorry,
respondent
sorry,
has
sorry,
not agreed.
Sorry, my lord. It's 6th Jan, 6/1/2020.
6/1/2023, the respondent has not agreed for appointment of an arbitrator. Thereupon, the petitioner has filed this petition. Paragraph. The agreement executed between the parties contains an arbitration clause. The respondent, despite being put to notice, have not taken any action to appoint an arbitrator. Therefore, PDJ. There's no list of PDJ. PDJ matter you are given, it's less than 1 crore. That's right. '97 means what must be the age? These people must be above 75 now. 78. Chairman. So and so. Any name you can suggest? Former PDJ.
As per invocation notice, we suggested Justice P. Durga Prasad. We suggested Justice
No,
P. Durga.
not you. We will this thing from the panel. 1 minute, I'll get. Shri B. What have you written, madam? For Mr. B. Gautam Prasad, former principal and district session judge Suryapet, he is appointed as an arbitrator to adjudicate the dispute. The parties undertake to appear before the arbitrator along with a copy of the order on 10th of September 2023. Accordingly, the petition is disposed of.
To the applicant notice.
First respondent, lordship, the counter has been filed by the first respondent.
It's coming for the counter of R2 to R6 now.
You have filed counter, right?
Because I am for the applicant. It was coming for R2 and R2 to R6 is counter, my lord.
I'm applying for R6 because I'm seeking time to file my counter. 3 weeks time, that's.
I'll leave it to them. He is my franchise, my lord.
Learned counsel for respondent number 6, praise one is granted 3 weeks time to enable him to file.
I mean, similarly, R2 to R5 also have to file the counter, my lord.
Let counter, if any, on behalf of respondents R2 to R5 also be filed on or before next date of hearing, then say list after 3 weeks.
Obliged.
Milords, I represent on behalf of the respondents, Milord. I'm for the applicant, Your Lordship. Milords, I represent the respondents. Request to 1 week time, Milord.
What is it? 2 weeks, finally 2 weeks time is granted to file counter, failing which appropriate order shall be passed.
Obliged.
Obliged.
Appearing for the applicant, my lord, applicant is a lessee. My lord, whose lessee, whose lease deed has been terminated.
I'm representing Srimati P. Sharda for the respondents in this matters, my lord. For the same issue, he filed 2 writ petitions before this honorable court, my lord, and this honorable court heard the arguments and reserved for orders, my lord, only day before yesterday. So I therefore request you.
This is not, this is a petition under 11.6, madam.
Yes, my lord.
So he is in
raised
the
that
petition also, he is seeking appointment.
He also raised that the issue in that.
Mr. Rao, you are a senior counsel, right? You have to be fair to the court. We will find out, but you should tell us what have you done.
My lord, as per the registered lease, my lord, there is a eviction notice that has been issued on 12/1/2023. My lord, we issued a reply invoking the arbitration clause at page 69, my lord, clause 46. To get over that termination of invoking of the arbitration clause, they issued a notice of Public Premises Eviction Act. It was challenged before the Honorable Court, my lord, single judge in a writ petition stating that when the arbitration clause has been invoked, it would not be right for the public estate officer to invoke the provisions of the Public Premises Act. That's not the arbitration clause. And my lord, the counter filed by them is totally silent on this issue. How the Public Premises Act is applicable to us?
So, madam,
These
this thing,
issues were raised before the.
madam, we will grant you time, and supposing if it is not found that in the writ petition he sought the relief of appointment of an arbitrator, we will impose exemplary cost on you. Understand, right? How in a writ petition he will seek appointment of an arbitrator, and which learned judge on earth will grant that prayer in a writ petition in the face of 11.6?
But if they read, I request.
You are ready, not ready. We will decide it, right?
I request 1 week time, my lord. My
Let's
senior.
say so, madam, in the beginning. Don't take chances with the court. It is not fair. That trying to know the mind of the court and then seeking time. This is not good. You should have said that senior is not there. I grant me time, understandable. But you are trying to know what is going on, whether the court will dismiss the his petition. Why we will dismiss? There is an arbitration clause. There is an agreement. There is an arbitration clause.
Yes.
If you don't this thing, we will appoint from the panel. We have the panel. We will appoint some. If you want time, be fair to say that that is understandable. But there is nothing to for your senior to argue in this matter. So and so praise for adjournment list next week. No further adjournment, right, madam? These are all not matters to be kept pending for like civil suits, correct?
May I make one request, my lord? Instead of 15th, my lord, that week, my lord, I have some difficulty on 8th, my lord.
15th September. No further adjournment.
Sure.
I'm sorry.
To any of the parties.
I'm sorry, my lord.
Don't tell me she is seeking adjournment. Yes.
Say, I think that matters.
Say.
Smaller property.
15. Hmm. 155, madam.
Then the council has requested time for 1 week fellowship has not.
Maybe you are requesting time. Who has requested time? You are not a messenger, right? Learned counsel for counter has been filed.
No, my lordship, personal notice has been ordered, my lord.
So why are you seeking time? They don't want. You don't want to file counter, right, madam? Then why should you not say? Let counter, if any, on behalf of respondents be filed within a further period of 2 weeks, failing which appropriate order shall be passed.
Lord, for the respondent, my lord, I filed my counters in this matter. The clause
File.
I filed my counter file, madam. Clause 25 of the agreement provide for arbitration.
Yes, Mr. Wu, are you contesting?
Yes, but I'm contesting, my lord.
Doesn't provide.
It provides. They agree, my lord, it provides. The stand taken in the counter is that the procedure mentioned in the clause 25 you did not follow, so the application is premature. That is the defense taken. My lord, the procedure says that according to clause 25, the parties should appoint their respective officers for the purpose of, my lord, dispute resolution. And, my lord, if that fails within 10 days, then they should go to some superior officer. If that also fails in 7 days, then, my lord, the party is convinced that, my lord, everything.
Which clause?
My lord, please take the count, my lord, filed by the respondent. Page 4, my lord. The bottom portion. Each party shall designate in the writing to the other party a representative who shall be authorized to resolve any disorder, dispute, controversy, or claim arising under this order in an equitable manner, and unless otherwise provided herein, to exercise the authority of the party to make decisions by order. The designated representatives are unable to resolve any such disorder, dispute, controversy, or claim within 10 days. Such dispute shall be referred by such representative to a senior officer designated by purchaser and a senior officer designated by supplier respectively, who shall attempt to resolve the dispute in a further period of 7 days. The parties agreed to use their best efforts to attempt to resolve all disorders, disputes, controversies, or claims arising hereunder promptly, equitably, and in good faith, and further agreed to provide in a timely manner each other with reasonable, non-privileged records, information, and data pertaining to any such disorder, dispute, controversy, etc. When a party has determined it has exhausted opportunities to settle any such disorder, dispute, controversy, or claim in accordance with clause 25(1)(a) and has determined that it desires to commence arbitration, it shall initiate arbitration in accordance with clause 25(2) hereof by serving upon the other party a formal demand of notice arbitration. In this case, it so happened in the month of March 2023, my lord has served a notice upon them saying that so much amount is due from you, you have to pay it. If you fail to pay it, I mean, I will have to initiate the arbitration proceedings. That was received by them in March 2023. It is admitted. They did not, my lord, respond to it. And, my lord, in June 2023, I filed the present application. Now they say that all this procedure laid down in this arbitration clause you did not follow. So this is a premature application. But what 11.6 says is that if one party to the arbitration agreement, if the procedure is prescribed, and one party fails to adhere to that particular procedure, other party can approach the court for purpose of appointment of arbitrator. But this clause 25 imposes a reciprocal obligation on both the parties. In this case, admittedly, my lord, they failed to respond to my notice. They did not, my lord, initiate all this procedure, etc. So, my lord, when there is a failure to adhere to the procedure, one of the parties, my lord, other party can go to the arbitration, my lord, under section 11(6) of the Act. So, that is, my lord, I mean, the objection is not maintained with my humble submission.
My lordship may see the clause in page number 33, my lord, the informal dispute resolution, what senior counsel has just read. My lord, the clause clearly says that, my lord, the party representative who shall be authorized to resolve any disorder, dispute, or controversy or claim arising under this order. My lord, each party shall designate in writing to the other party a representative who shall be authorized to resolve. Insofar as the notice is concerned, under the instructions of the client, the notice has been issued. He is not authorized, my lord, to be a representative to solve this dispute. Lordship are very much aware of Simpark infrastructure judgment, wherein the Honorable Court is very clearly held that, my lord, when parties agreed for a particular procedure for a dispute resolution, the difficulty is it is Simpark infrastructure versus Jaipur Municipal Corporation. I will submit by a compilation, as 6 judgments I have taken. I will submit by a memo and a compilation, my lord.
No, at a future date, when petition will be decided,
My lord, the difficulty was, my lord,
Why did you not tell that you want time? You wanted senior counsel to argue and tell him, tell you the point so that you can prepare after 15 days.
to the great respect to senior counsel, I didn't want to intervene, my lord.
Tactics like this, are you young, too young?
To great respect to senior counsel, I didn't want to intervene.
Why did you make him argue then? You should have said that, sir, I want time.
To respect to the bar, senior counsel starts, my lord, I kept quiet, my lord. With great respect.
Yes, Mr. Counsel.
It's a double-edged method.
It's a double-edged. No, these people, that's what you were 5-year course, right?
Yes, yes.
This is what you have been taught. Which school?
No, I'm from Usmania University.
This is a university has taught you, like, you make senior counsel argue and thereafter say that, why have you not brought that judgment?
Well,
why did you not bring the judgment? Please tell us.
I have a digital.
We will have it, Mr. From. You go ahead. I will ask the senior counsel. He will furnish. What is that citation?
Assuming that, my lord, the courts have held, my lord, that unless the procedure prescribed in the arbitration clause between the parties is adhered to, party, my lord, cannot approach the court for appointment of arbitrator. My lord, I assume that, my lord, legal position is settled on the.
Like that.
Yes,
I have also read it.
So my answer to the particular issue is like this. My lord, this particular clause which I read out, your lordship already, your lordship please to read it. My lord, imposes corresponding, my lord, obligations on both the parties.
What was the clause in that case?
That is, my lord, I do not know exactly the clause on which he is going to rely upon. My lord, this clause, this case.
See what, how smart the Usmania University people, university law courts make them.
As far as that is concerned, I am in dark as on today.
You find out, Mr. Next week we take up.
As the lordship says.
Next week, because we need to know the law.
Next week, my lord,
don't, Mr. On the next day, don't do it. That I will, thereafter, next week, I will submit. It will be
Before a day.
we will record in the order sheet that you have only mentioned party's name without supplying a copy, and court is under no obligation to search it.
I'm representing my colleague, man. That is the difficulty.
That shouldn't argue.
Before even next date of hearing, I shall submit the compilation of judgments along with the memo and take through that.
This by means of this petition under section 11 within bracket 6 of the Arbitration Conciliation Act, the petitioner seeks appointment of an arbitrator. Clause 25.1 of the purchase order reads as under. Quote it, madam. This. Learned senior counsel for the petitioner submits that. When did you give a notice, Mr.
13th of March 2020,
that the petitioner gave a notice to the respondent on 13th of March 2023, asking it to do what?
Asking the amount to pay to me, or else
asking the amount due to be paid to it, or else, or to refer the matter.
Yes, or else I'll go for arbitration.
Failing which the respondent was informed that the petitioner shall take recourse to clause 25.1 of the purchase order. However, the petitioner neither responded to the respondent did not respond to the aforesaid notice. It is further submitted that clause 25.1 cast reciprocal obligations on the parties, and on failure of one party to take the to take an action under 25.1, the other party can approach the court seeking appointment of an arbitrator. However, learned counsel for respondents prays for adjournment on the ground that the arguing counsel is not available. List in the next week.
Well.
Wait, please, my lord.
My lordships, I am appearing for the respondent, my lordships. I'm requesting 2 weeks time, my lordships.
This is this is the cardamom matter where the division bench, my lords have said, adjournment will be sought in the section 11 petition. It is coming up today, my lord.
No, my lordship, the arguing counsel is unwell, my lordships. That is the sole reason.
Where is that order?
Yes.
Despite giving an undertaking, if you breach it, what what is?
Here, my lordships has said, my lordships, 48 hours is there to file a counter. That is by what my lordships has said.
48 hours?
Yes, my lordship, because it was had just day before yesterday.
He is referring to the division bench judgment which was rendered day before yesterday. I had 48 hours to file counter. If I understood him correctly, that's what his submission is.
48 hours to file counter?
From the time of the judgment of the division bench.
No, last time, 11/8/2023, you were granted 2 weeks time.
Yes.
That is the first, no, my lordship, that is the first appearance, my lordships. The another.
No, 1 minute. So therefore, your contention is that for 1 year, you will not file counter.
No, my lordship.
And
Within
this thing.
a week, I will file a counter.
The order passed by the division bench is binding.
My lord, I have reserved my lord liberty in para 10 and 11 to oppose the arbitrator under section 17.
No,
Unless there is no record with respect to that.
We will give him 1 week. There is no like that.
No, that there is not there. But my lords on that day.
Mister, you argue next week, otherwise we will proceed.
The arguing counsel will argue, my lordships. That is, it is unwell today, my lordships. That
You
is
are,
the-
you are counsel seeking adjournment.
Yes,
And you will never evolve yourself to arguing counsel.
No, my lords, I will appear. If the arguing counsel is not appear on the next date, my lords, I will appear personally.
Person, you are an accused before this court.
No, my lordships, because my lordships,
Are you impersonating today? Not
my lord.
appearing in person.
No.
All we are saying is, you are a young man, prepare the case and argue. Don't seek an adjournment. That's what we are saying.
very
That you are saying, I am appearing in person. I will appear in person. That means you are not appearing in person. You
Very
are
well, my lord.
somebody else. You are impersonating someone.
No, my lords, no.
Then
I'm just.
why should you say person? We are only emphasizing, Mister.
Yes.
Argue.
And
This is 11/6, nothing.
only issue is, my lordship, the non-party is also made an applicant, my lordship. That is the issue. That's why I need to file a counter.
That is decided by the division bench. I don't think they have that ground left anymore.
Whatever.
But the question
He is not appearing in person today. How can you, can you argue against your opponent who is not appearing in person?
Yes, correct.
No, my lordship was about to say, my lordship, if I am,
You are
the opinion that I am only seeking
One
time.
Mr. Vishnuvardhan.
Yes, my lordship.
You are, last time also you prayed for 2 weeks
I
time.
appeared in 11/6 application, my lordships, not in the application C. I have not appeared.
No, 11/8/23,
Yes,
Mr.
my lordship.
Vishnuvardhan.
I appeared. Not in COCME, I have not appeared, my lordship.
Nobody-
COCME has taken.
Mister, nobody is asking you about COCME. That is not the subject matter of this appeal, petition. This is a petition under 11/6.
Very well, my lordship. Next week I will submit.
You have filed counter
No, my lord.
For the counter, my lordship, I am seeking time.
and then for argument, right? No, we will say in the order sheet, you will file counter within a week and get ready also within 1 week.
Oh, bless my lordship. Oh, bless my lordship. Very.
You come here to argue cases, right? Come to the court to seek adjournment or say that arguing counsel will argue.
No, my
So then
lordship,
don't
that
appear.
is not
Don't-
what I meant, my lordship. I apologize. I apologize.
Before this court, we don't like young people seeking adjournment and telling arguing counsel will argue. You are not
Stand corrected, my
You are
lordship.
not postman giving information to this court. You are an officer of the court. Responsible person, right? We give you so much of respect. Don't this thing.
No, my lordship, I have already upfront. My lordship, in the morning only I have informed to the learned senior counsel, my lordship. I did not mean to make him wait, my lordship.
Mr. Vishnuvardhan, learned counsel for respondent was granted 2 weeks time to file counter on 11/8/2023. However, he has not filed counter. By way of indulgence, a week's further time is granted to enable him to file the counter and to prepare the case.
Oh, bless.
List on 8th of September 23.
Bless.
The appellants are the lessors, my lord. They are the owners of the property, my lord.
Not appearing, nobody.
No, none appeared, my lord. It's the third time coming up before this honorable court. This is the third time.
You have filed proof of service.
Proof of service filed, my lord.
Filed?
Yes.
See, madam.
But the arbitration arbitration clause contains, my lord.
1 minute, one.
My lord, page number 25 is the arbitration clause.
25.
Yes. Clause number 15, my lords. Lordship said after 5 I will not pass order, but it's last occasion Lordship said after 5 I will not pass order, but it's 4:30, my lord.
Just
I'm
like,
fortunate with that.
yes, you have commenced. So whatever has commenced has to be concluded.
Thank you, my lord. Thank you, my lord.
Yes, 25.
Clause number 15, my lords.
Oh, yes, yes. So what is the extent of dispute? How
The
much
value
quantum?
is below 1 CR, my lord. That is 35 lakhs.
DJ.
Yes.
Yes, this petition under 11(6) of the Arbitration Conciliation Act has been filed seeking appointment of an arbitrator. Despite service of notice, none has appeared on behalf of respondent to oppose the prayer. Paragraph. The parties have entered into an agreement on parties have a lease deed. Delete a lease deed dated 5/5/2022 was executed between the parties. Clause 15 of the aforesaid lease deed contains is an arbitration clause which reads as under quote. Paragraph. Despite service of notice on
legal notice issued on 25/4/2023.
25/4/2023, the respondent has not taken action to appoint the respondent has neither responded to the notice nor has taken any action in terms of clause 15 of the agreement. Full stop. Paragraph. The dispute between the parties is required to be adjudicated in accordance with clause 15 of so and so. Therefore,
The tribunal consists of 3 members as per the clause 15, my lord. Oblige.
we are appointing a judicial officer. Therefore, Mr. P. Raju, no, 1 minute. Shri B. Sathaiya, whatever, is former principal and district session judge, Mancherial. It's a big place, Mancherial. Mancherial is a big place, commercial place.
My lord, all the parties are domiciled at Rangareddy, my lord. Yes, my lord.
Acha, all right. Shri S. Hare Krishna Bhupati. Who is Bhupati? He is resident of Rangareddy district.
Yes.
He is appointed former principal and district judge. LB Nagar Rangareddy district is appointed as an arbitrator, sole arbitrator to adjudicate the dispute between the parties. The party shall appear before him with a copy of the order on when 10th of September. 10th of September 23. Accordingly, petition is disposed of.
May I further mention, my lord? I have sought for interim reliefs in these applications also,
No
my lord.
interim relief, nothing. Under section 17, filed interim relief. Yes. Yes, madam.
Your Lordship, I'm for the applicant, Your Lordship, memo, proof of service filed, Your Lordship.
You have filed?
Yes, Your Lordship.
See, madam, proof of service.
USR,
Served, madam.
USR 78832 of 2023.
Notice returned as addressee left. Notice issued to the respondent has been received with the endorsement that the addressee is left.
Your Lordship.
In view of proposed endorsement, legal counsel for the petitioner states that petitioner shall take steps within 3 days to within 3 days to serve the respondent. You want personal notice, proof of service. Yes.
I'm representing on behalf of counsel for petitioner. It's coming for counter, my lord. Last time they have a short time for filing.
No,
but not my demand.
Let counter, if any, on behalf of respondent be filed.
My lord,
Within 2 weeks, list thereafter. This is for hearing, mister. You should argue. Nothing to argue in. Yes. Yes, madam.
For the applicant, my lord. Services filed in written response.
Right, sir. What is this thing? Claim.
My lord, it's 3.4 crore.
So we'll appoint, nobody is appearing. Another judge.
My lord.
Another judge of this court. Justice G. Raghuram won't take up, right? Justice G. Raghuram won't take up. Huh? Huh? Where is that? We'll appoint Madam Justice A. Santosh Reddy. This petition under 11.6. Same matter. Huh? Neither appeared nor this thing. Agreement contains agreement dated Madam.
41/1/2022.
31/20/2022. Clause, which clause? Annexure 1 to agreement dated 31st of January 2022 contains an arbitration clause which reads as under. Despite notice being served, respondent has not taken any action. Therefore,
Their name is reflected in the cause list, my lord.
nobody is appearing. Then you should have said, no, madam, we are thinking that they are not represented.
My lord, so name is
Next week. None for respondent awaiting appearance on behalf of respondent. Hearing is deferred. List next week.
I appear for the respondent in this matter, Your Lordship, requesting time to file counter.
How much time?
3 weeks, Your Lordship, may kindly grant.
What is it? 2 weeks is enough? No.
Very well, I leave it to you.
All right. Learned counsel for respondent praise is granted 3 weeks time to enable her to file counter. Do so positively.
Yes, yes.
Next date.
Obliged, Your Lordship.
None.
My lords, I am appearing for the applicant in the matter. This is an application.
What served, madam? No, not served.
My lords, the matter is coming up for the first time. It's an application under section 11(6) of the Arbitration Act. The parties had entered into an agreement of sale dated 28th Feb 2000.
Learned counsel for the petitioner submit that clause. Which clause?
Clause 10.
Clause 10 of the agreement.
28th February 2021.
28 February 2021 contains an arbitration clause. Notice.
My lords may permit personal notice, my lord.
Personal notice, proof of service.
Obliged.
Well, this is an application under 29A seeking an extension of the arbitral time period. But the time period gets over on 29/8/2023. But arguments are completed. 29th August 2023. But arguments are complete in the matter. It's a panel of 3 arbitrators. But we are only seeking an extension by a period of 6 months. 4 months is what we are asking, my lord. 6 months is what can be granted at one time.
So arguments have been heard. We will let us expect 4 months.
Yes, Rochester granted.
Yes, this petition, mark the presence. This petition under section
29.
29A of the Arbitration Conciliation Act 1996 has been filed. Seeking what? Extension?
Extension.
What is the prayer?
Extension of time.
extend the time for completion
extension of time to complete
the arbitration proceedings and making arbitral award, Your Lordship.
and to make an arbitral award. Paragraph after hearing learned counsel for the parties and for the reasons assigned in the application, time for making the award is extended up to
A period of 4 weeks, 4 months, Your Lordship makes it.
by a period of 4 months
Yes.
from today,
But from 28/9.
from
29.
28/8
2020.
29/8/2023. That's why we, instead of doing so, we wanted date to be mentioned.
Yes.
Up to which the 4 months will expire when December.
29th December 2023.
So you say from so and so extended up to 29/12/2023. Accordingly, IA is disposed of.
Deeply obliged.
Time for completing the arbitral proceeding and passing in arbitral award is extended up to so and so 2019. 5 years disposed.
Wait, please, my lords. Petition filed under section 29A of Arbitration Conciliation Act, praying my lords to extend the period of arbitral proceedings by 6 months. The oral arguments are pending, my lords. Written submissions have already been filed.
Learned counsel for this petition under notice has been issued.
Notice, no, first time it is coming before my lords.
Then notice.
Next week
Issue
we take-
notice on IA 1 of 23. You issue notice of this IA personal service proof of service.
Next week, my lords.
We don't know. Can you serve by that
Yes, my
time?
lords. He is available. He is also available.
List on next week is 8th September.
Much obliged.
But petition filed for return of marked document.
Huh?
Return of marked document.
Return of original documents.
Original document.
Petition has been filed. Huh? Yes,
filed,
madam.
Notice, sir.
Filed for return of original documents on this thing on substitution of the original documents by a duly certified copy by the petitioner, original documents be returned to him. IA is allowed. Subject to aforesaid, IA is allowed.
My lords, I am appearing for the petitioner in item number 167 through VC.
167.
Yes, my lords.
But nobody's served.
My lords, service has been done.
What is the arbitration clause, Mr.
My lords, page 27, clause number 7.
Clause 7 of agreement dated
12 September 2018.
Huh?
12 September 2018.
When did you send a notice?
My lords, I sent a notice on 10th March 2023.
What is the this thing your claim?
My lords, my claim is for 1 crore 35 lakhs 82,979.
So you are based in Hyderabad, right?
Sorry, my lords.
You are in Hyderabad.
My lords, the petitioners are from petitioner and respondents are from Hyderabad.
No. So you are appointing Justice A. Santosh Reddy.
My lords, I have proposed Mr. M. Madhusudan Reddy.
No. You have come to the court, right? Other side is not appearing. So any farmer judge of dispute will do. Right.
Obliged, my lords.
Madam, petition filed under 11(6) of Arbitration Conciliation Act, clause 7 of the paragraph, clause 7 of the agreement dated 12/9/2018. Which page agreement?
Sorry, my lords.
Which page is the agreement, clause 7?
Page number 27.
Page 27, right? Contains an arbitration clause. Aforesaid clause reads as under paragraph. The petitioner has sent a notice to the respondent on 23/3/2023. However, neither petitioner has respondent has neither responded nor has taken any steps, right? The dispute, the arbitration agreement, the agreement contains an arbitration clause. Therefore, dispute needs to be referred to an arbitral tribunal. Mr. Santosh Reddy, Justice A. Santosh Reddy A. Santosh Reddy, former judge of this court, is appointed as an arbitrator to adjudicate the dispute between the parties. The party shall appear before him along with copy of this order on 10th of September 23 at 11 a.m. Accordingly, petition is disposed of.
Obliged, my lord.
Appearing for the applicant in this matter, respondent's counsel filed wakalat, but there has been no representation on multiple occasions, ma'am.
Next week. None for respondent list next week. Yes.
My lords, representing for applicant, my lords. My lords, in this matter.
Nobody is appearing.
No, my lords, the notice has been sent. It has been returned as unclaimed, my lords.
Unserved.
Unclaimed, my lords. So served in service.
Unclaimed.
Indeed, my lords. My lords.
Then office this endorsement indicates that notice issued to respondent has been received back served. Received back. No, what received unclaimed. Therefore, the respondent is deemed to be duly served.
The same.
Petition has been filed. Appointment. You in the beginning, right? 11.6 was for seeking appointment of an arbitrator. Clause.
Clause 14.4, my lords.
The agreement dated.
Of agreement dated.
Not filed.
You filed, my lords. This is the synopsis, my lords. Your lordship said in the last occasion directed to submit a synopsis. My lords, the agreement dated is 2/5/2022, my lords.
Right, madam. That's nice.
It's in the next page, my lords. List of.
The registered lease deed has been executed between the parties on 2/5/2022. Clause. Which clause?
15.4, my lords.
So that the this thing agreement contains an arbitration clause which is reproduced below for the facility of reference. Paragraph the a legal notice dated 6/10/2022 was served by the petitioner, pursuant to which a reply was submitted on 7/10/2022. Thereafter, another legal notice dated 28/1/2023, the respondent was informed that it is proposed to appoint that the petitioner proposes Shri M. Venkatramana, retired judge of High Court of Andhra Pradesh as sole arbitrator. The aforesaid notice has been received with the endorsement that same has not been claimed. The notice of this proceeding was also sent, which has been received back with the endorsement unclaimed. Paragraph. The dispute between the parties requires adjudication by the arbitrator. You are based in Hyderabad.
Based in Hyderabad.
The respondent, the petitioner as well as respondents are based in Hyderabad. Therefore, Dr. Justice Shamim Akhtar is appointed as an arbitrator.
My lords, me.
Sole arbitrator to adjudicate the dispute. You cannot have of your choice, right? Huh? And don't make such expression from which we can make out that it is not to your liking.
No.
We are telling you, madam, you are a young advocate. We are telling you, don't make, because you don't realize, but I could see that it is not to your liking. Right?
Apologize.
Don't do it. A judge is a judge, former judge is a former judge, and his name appears in the panel.
Indeed.
Hyderabad is appointed to adjudicate. Shall appear before 10th of September 23 at 11 a.m. Accordingly.
Obliged, my lords.
144 we have carried out. Item number one.
Done all right. It's all done.
Yes.
List is over.
No, my lords, 144, we carried out the amendments, my lords. Where the,
So thereafter we said that, no, you are asking the court what order has been passed because you forgot about it.
no, my lords, no, my lords. We have made governor party, my lords have directed us to make corrections. We have carried out the correction, my lords. We are only requesting to issue a fresh notice to respondent number.
That has already been done. If you are not attentive in the proceeding, Mr. This is not fair to the court that asking the court what has been passed.
My apologies. My apologies.
Don't have this like a short-term memory of 15 minutes forgetting whatever happens. I remember that I have dictated that after correction, issue notice to respond number 4. You have forgot.
My apologies.
Asking. Which, madam, read order.
My apologies. My sense. My sincere apologies.
Not good short-term memory, not good for young people like you. Huh? Eat something to enhance your memory.
Very much.
What is this?